Good afternoon, dear ladies and gentlemen, dear colleagues, dear participants, dear judges of the Constitutional Court, dear representatives of international organizations, and all participants who are participating online. First, I'd like to greet my colleagues, our co-citizens, our judges, and our patriots on the occasion of this day, the only state holiday mentioned in the Constitution is the Day of Constitution. The rest of the holidays are identified by the law. So it is one of the greatest holidays after the Day of Independence is the Constitution Day. We have just seen a couple of seconds of the touching video, a very touching moment, or some moments of time that we were very emotional about at that time. And those emotions and tears in the eyes of many members of parliament, they were provoked by the number of factors. However, the most important was that the event took place against something and because of something. If we look at positive sides, what were the factors that contributed? It was the aspiration of Ukrainians to the statehood and adoption of the constitution. Before 28th of June, we lived by the temporary constitutional act, the constitutional agreement, and before that, I have the last version of the Constitution of Ukraine. As of 1994, it was written Article 1, this is 1994, Ukraine is the people's state which expresses the will and interests of the laborers, peasants, and intelligent people, the workers of the Republic of all nationalities. And the second article, all power in Ukraine belongs to the people, and the people exercises power through the people's deputies, who are the political basis of Ukraine, and all other state bodies are controlled and accountable to the councils of people's deputies. So all power was in the hands of councils, as it was declared by Lenin in Petrograd. These were the changes that we had, and the tears in the eyes of members of parliament. So those emotions were the demonstration that this actually happened. And what happened? Ukraine or Ukrainian people, in democratic way, approves the constitution. In the democratic way, they voted for the constitution. It was the exception, because the biggest countries of the former Soviet Union had to create new union, Russia, Belarus, Kazakhstan. Their constitutions were adopted through referendum. It was in the way of manipulation of referendum. And what kind of constitutions they had? So the constitutions were autocratic with two-chamber parliaments with strong presidents. Even until now, what is their political essence? It is autocracy. Ukraine was the fourth in the list. And at that time, when members of parliament voted and the constitutional night, there was constitutional order of the President Kuchma. And he submitted to referendum the same model constitution as Lukashenko, Nazarbayev, and Yeltsin. We were in the queue, number 4 in the queue, to establish the union of the 4 countries. However, the parliament of Ukraine, despite the political dependence of all MPs, managed in the democratic way to vote for the constitution. And this is the exception, which proves that Ukraine is committed to democracy. And even at that time, at the moments of deep political crisis and opposition, because Kuchma orders not to approve the constitution, this constitution, and he ordered that his constitution should be adopted at the referendum. Kuchma created a special representative responsible for not approving of this constitution by the parliament in the democratic way. It was deceased MP Yemets. Kuchma orders Prime Minister Lazarenko to remove all the ministers who were MPs to the city of Cherkasy for all Ukrainian council and production of alcohol. And so they moved out those MPs who were ministers at that time, to avoid quorum to undermine the adoption of the constitution. The Minister of Justice was the only one who stayed there. It's me, and I had to be fired next day, but I was not. The minister stayed as the Minister of Justice for 1 more year after that, and so that shows that in Ukraine at that time democracy won. It is the great day of the constitution. It is the great day of democracy. And when we were thinking on selecting the topic for today's discussion, of course, since then many years passed. It's 27 years since then, almost 30 years, and I thought, let us look back at this 27 years. And the text was drafted before that, even earlier, and what was put into the draft is important. And today Ukraine has different legal status as the EU candidate country, because at that time Ukraine didn't have the constitution, but it was already the member of Council of Europe. It was also exceptional. We were accepted to the Council of Europe as an exception. So let us think over the values on which the Europe is built, where we're aspiring politically and legally. And so this is the democracy, first of all, or it is the triad, rather, the triad. It's equally significant values of democracy, human rights, and the rule of law. And let us look at our constitution, not from the political perspective, but from the legal perspective. Maybe we need to have all national discussion of the experts on what is there. I have some technical problems on the line. If we look at these things, I will cover 4 points here. First point, we do not accuse anyone, and we cannot accuse anyone with the text which was drafted, because it was the political compromise. On one hand, to defend the democratic process, and on the other hand, it is
нас не вчили конституційному праву, так же? Нас вчили державному праву. У мене в дипломі я подивився советское государственное право, государственное право СССР и зарубежных социалистических стран, государственное право буржуазных и развивающихся стран. І тому тоді навіть, мабуть, не було того, що потребується для усвідомлення сутності самого явища поняття Конституції як не просто акта позитивного права, а як явища у суспільно-політичному бутті народу, нації, держави. І оця мантра, яка в нас записана, Конституція, або на яку відповідає кожний студент, Конституція – це основний закон держави. Вона мене кожен раз пробуджує, і мені моторошно від цього, бо це не закон держави. Наш навіть Конституційний суд витлумачив, що це акт установчої влади народу. А студенти нам кажуть, Конституція – це основний закон держави. Я от подумав, а де це взялася мантра? Я знайшов. Ця мантра знайшлася з царської Росії. Тому що цар Микола II у 905 році видав основний государственний закон, проте, утворивши своїм маніфестом Думу, про те, скільки ж повноважень матиме Дума від його необмеженої влади як самодержця. І от російські оці закони називалися «Основні государственні закони». І, звичайно, що концепція чи сутність явища «лекс фундаменталіс», яка йде від античних часів, проходить через 18 століття, коли народжуються перші демократичні конституції, які валять самодержавство або утворюють державу як незалежну від метрополії, від імперії. І цей лекс фундаменталіс це
And
не
this
є.
lex fundamentalis is not the basic law of the country, but this is just to have the idea. Second is democracy. 28th of June is the Festival of Democracy, 1996. But let's look at the current text. Maybe we need to get rid of communist, totalitarian institute of imperative mandate. So this is incompatible with democracy, the imperative mandate of the member of parliament and the requirements of free democratic society, free democracy, liberal democracy. If we look at the components in the triad of European values is the human rights. And it is the third article in the groundwork and the human rights. When I see this participation, the charges know that we try to put social into parentheses, the word social in parentheses, the social value. The human is the social value. It is Marxism, but it is part of our law. It is the habits that the human is perceived like that. Let me quote a sentence. The article was called on the leadership of the activity of the people's judges. This is the Red Law, 1929. What the author wrote: the Soviet legislator should construct the dignity of the person only as the object, only as the social value of the individual in the society. This is Marxism, right? So we need to think about this when we need to remove Marxism from the text. When we talk about human rights, we need to rethink how we get rid of other remains of the socialist science, quote unquote, of the Soviet law, where it was reflected through the formula of the second title, the rights and duties of the individual and the citizen. Rights and responsibilities of the human and rights of the citizen and duties. So the issue of the duties. When we say about duties, is it the duties of the human? Is it duties to God? And duties of the citizen to the state? It is the Soviet formula. It was borrowed. Our guest is the representative of France, of course, because in the Declaration of Rights, the Declaration of Rights of the Human and Citizen of the 18th century in France, this is the declaration which has the concept of philosophy, of the concept of droit de l'homme, rights of man. The rights of man and citizen, especially for the French, it was the issue of property. They didn't want English to own some things, and the concept of 18th century is not the human rights per se. And so people refused from it. This concept of 18th century of the rights of man, it had limited nature. It covers not the numerous group of owners of property. It did not cover women, it did not cover children, and also all those who did not possess any property, and all those who did not belong to the white race. This is the concept of the rights of man, even in the United States of America, which are founded on the basis of the values of liberal world. So the concept of human rights, the rights of man, was not the obstacle to destroying indigenous people, to slavery of the black people. So the concept of 18th century, which covers the concept of rights of man, was based on the distorted concept. It's covered only a limited number of individuals, and these were not human rights. These were not human rights. And let me move to the third component. And the third component is the rule of law in the light of European values. We have some achievements in this regard. After the reform of 2016, we deprived the political institutions from the impacts on selection of judges, appointment of judges. The president has only formal registrate role. The Supreme Council of Justice, in terms of numbers, is in line with European standards now. The majority in the Supreme Council of Justice are those who belong to the judiciary profession. The Supreme Council of Justice has all the procedures of selection of judges, evaluation of judges, the career development of judges, the responsibility, all this belongs to the Supreme Council of Justice, and this means independence of judiciary. We have done many other things as well, but now it's not all. The rule of law requires more. The rule of law requires that as the prosecutor's office, as the institution of criminal prosecution, and it should be also depoliticized, but it is politicized until now. The parliament has the right to express political vote of no confidence to professional position, to the person who occupies a professional position. This is politicization and it should be removed. Moreover, what the rule of law requires, the rule of law requires a special majority, qualified majority, to appoint to those positions which are in the system of rule of law, like the general prosecutor should be qualified majority, or the constitutional court judges, which are appointed by the parliament as political institution, or judges who are appointed by the votes of the judiciary profession. Also, 2/3 have to be there. The ombudsperson of the parliament for the human rights also should be appointed by the qualified majority. And we have room for improvement in this sense that we need to do this at the stage when we move to the EU.
Визнавати суверенітет, визнавати юрисдикцію наднаціональних органів в особі Європарламенту, Єврокомісії, юрисдикцію Люксембурзького суду, але це далеко. Те, що я перед тим говорю, це раніше треба робити, бо воно зараз уже має
What I said we need to do it earlier, because even now it should be in line with rule of law requirements. So having chosen this topic, the triad of values in our constitution and light of Eurointegration,
які визначає наша програма. Я щиро вітаю всіх.
So we'll discuss this under our agenda. Greetings on the occasion of this conference, and I pass the floor for the greetings to Wolfram HERTIG, the senior manager of the projects, deputy chief of departments of the East Europe from the German funds, please.
Дуже дякую. Dear Mr. Acting Chairman of the Constitutional Court, dear Professor HOLOVATY, dear judges of the Constitutional Court of Ukraine, ladies and gentlemen, dear friends. On behalf of the German Foundation for International Legal Cooperation, I would like to congratulate you on the occasion of the Constitution Day of Ukraine. Best wishes and warm regards from our director, Stefan Hülsöster, who had on very short notice to be in Berlin today, and therefore is unfortunately currently unable to attend. So I have the honor of welcoming you today. In these times of war, of aggression against Ukraine, the Constitution Day of Ukraine has a very special value. It is a sign of hope and a sign of the strength of the rule of law. The whole free world is impressed how Ukraine and the Ukrainian people are defending liberty and democracy, and how you continue your legal reforms even under these challenging conditions. We can only express our deep respect about this. Dear Mr. Acting Chairman of the Constitutional Court of Ukraine, Professor HOLOVATY, just 2 weeks ago, IRZ had an online expert meeting with the Constitutional Court of Ukraine and 2 retired judges of the German Federal Constitutional Court. During these discussions, you and your colleagues have emphasized the important role of the Constitutional Court, especially in these times of war, in order to strengthen the confidence of Ukrainian citizens in their state, resisting the threat from outside. And in November, we will continue this dialogue in the premises of the Federal Constitutional Court in Karlsruhe. Since June 2023, when Ukraine has been granted the status of candidate of the European Union, you have even intensified your reform efforts. We are honored to support you in these challenging activities of approximation of your national law with the law of the European Union. Thank you very much for allowing us to be represented by an expert at today's conference. And I would like to thank Professor Dr. Lars Brocker, President of the Constitutional Court and of the Higher Administrative Court of Rhineland-Palatinate, that he will contribute a presentation on decisions of the Federal Constitutional Court of Germany regarding the principles of the rule of law. Many of you know Mr. Brocker as he is a long-time and real friend of Ukraine. In 2021, Mr. Brocker also took part in this conference of the Constitutional Court and gave a presentation on the Constitutional Court of Ukraine and its involvement in European fundamental rights. Today's conference will show once again that Ukraine is part of our European community of constitutional and democratic values. The IRZ, working on behalf of the German government and especially of the Federal Ministry of Justice, will continue its close and intense cooperation with our Ukrainian partners and with the Constitutional Court of Ukraine in order to strengthen the rule of law and the EU harmonization process. We wish you every success on the path of reform and the approximation of your national law with the law of the European Union. And first of all, we wish you peace, security, and recovery of the full territorial integrity of your country. Best wishes for Ukraine, for its constitution, and for the Constitutional Court of Ukraine. Thank you for your attention, and I wish all of us fruitful discussions. Дуже дякую. Thank you.
Щиро дякую вам, пане Вольфраме, за ваші
Thank you, Mr. Wolfgang, for your kind words, for the greetings, for the feeling of solidarity with Ukraine and Ukrainians in their fight for their statehood, sovereignty, for their freedom, and for the major right, the right to life, the right to life of an individual and the nation in general. Thank you very much for your fruitful and long-standing cooperation with the Constitutional Court, and we express our readiness to continue this cooperation. And now I will give the floor to Ms. Pierre, who is OSCE SPU Support Program Manager. And this is one of the most powerful institutions in Ukraine, I would say, that has supported the Constitutional Court for a long time through organizing various events, conferences, trainings, and it is the top, I would say, international organization in this regard. The German fund is the national institution that supports cooperation with the Constitutional Court. OSCE, on the other hand, is the top international one. Mr. BAUSSAND, the floor is yours.
Your Excellency, the President of the Constitutional Court, Your Excellency, the Speaker of the Verkhovna Rada, and then distinguished judges of the Constitutional Court, ladies and gentlemen, it's my pleasure to participate in the opening of today's conference. And and to congratulate all of you on the occasion of the 27th anniversary of the Constitution of Ukraine. Today's conference brings together a number of judges, representatives of the parliament, academia, civil society, as well as international community to reinforce a dialogue platform and acknowledge the support to your work during this devastating time for Ukraine. We commend the resilience of the Ukrainian partners, of your institution, to continue to uphold the values of democracy, human rights, and the rule of law, which are our common values that enshrine in the international legal instrument and in the Helsinki Final Act. They have inspired us and guided us for nearly 50 years, and it's precisely during time of war and armed conflict that the triad of European value, and I will repeat, democracy, human rights, and rule of law is called upon to play its vital role. And the Constitutional Court is central in safeguarding these values. I would like to thank the President of the Constitutional Court for highlighting the role of the OSCE. As it's true that we have been cooperating with the institution for many years. This year, we want to support the democratic and social resilience of Ukrainian institutions, civil society, and the people of Ukraine. With tailored project, we support the facilitation of the expert dialogue and exchange of experiences with the constitutional courts in the OSCE areas. Special emphasis is placed on promoting access to and accessibility of constitutional justice to ensure better access. Yes, please go ahead. Because we want to ensure better access of people to the constitutional justice tools and to focus through project on gender equality and on the defense of vulnerable people. The OSCE is a big family, so I'm glad that today ODIHR's Carolyn HAMMER is with us in the event. And as the president of the court mentioned, I hope that the OSCE has been an effective instrument for promoting the value we will discuss today. We stand ready to continue the excellent cooperation with the Constitutional Court all our stakeholders, including academia and civil society. This event today is a good example of our readiness to support you. I would like to say thank you to the Constitutional Court of Ukraine, to the Council of Europe, to the German Foundation for International Cooperation, who join all the efforts today to make an idea a reality of us today. Thank you very much to everyone.
Merci beaucoup, Monsieur Pierre Vasyl.
De rien, Monsieur le Président.
Of course, from my side, I would like to thank you for the welcoming remarks and for the long-standing cooperation with the Constitutional Court. I am sure that our further cooperation will remain fruitful, mutually beneficial and very useful for the Ukrainian people. And the Constitutional Court, as an institution, will strengthen its institutional capacity in fulfilling its major role. First of all, protection, constitutional protection of human rights and fundamental freedoms. Dear colleagues, we were supposed to have some other welcoming remarks from other officials, but they cannot get connected to us. Nonetheless, it doesn't change anything because we need a 5-minute break in order to rearrange the presidium.
Так, шановні пані, панове, продовжуємо.
Okay, ladies and gentlemen, dear guests and friends, we continue our work. And I will be ceding my moderator's authorities to my colleagues. They will be moderating the 3 sessions that we are going to have during this conference. And they coincide with the triad of European values: democracy, human rights, and rule of law. So now we will be speaking about democracy. In 1996, democracy prevailed over autocracy. So it is my pleasure to give the floor to my colleague, Olga SOVHYRIA, to moderate in this session. Dear colleagues, participants of the conference, I am glad to welcome you at our international conference that is dedicated to democracy as a key democratic value. Okay, first of all, I would like to thank the armed forces of Ukraine that with their bravery are protecting European values at the battlefield with the aggressor, thanks to which we have this opportunity to be together and to work fruitfully. The Constitutional Court of Ukraine grounds its decisions on the principles of democracy, like in the cases on the social protection of the military, the ownership rights, the issues of self-governance, taxation, etc. On the 1st of March 2023, the Constitutional Court of Ukraine affirmed a judgment pointing to the principle of democracy, whereby the constitutional order in Ukraine is based on the principles of democracy, rule of law and separation of powers. In another judgment of the 20th of June 2019, the Constitutional Court underscored that the rule of law as a normative ideal pursued by every system of law as an universal and integral principle of law should be considered in the context of such fundamental components as legality, separation of powers, sovereignty, national sovereignty, democracy, legal certainty, and fair trial. And in its decision of the 23rd of January 2022, it confirmed its legal positions that democracy is one of the fundamental components of the constitutional principle of the rule of law. In its decision of the 16th of July 2019, the Constitutional Court, referring to the case law of the ECTHR in the context of certain measures taken by the government to ensure the stability of constitutional rule, says that every time when the state refers to the principle of democracy and ability to protect itself, to justify the interference into the human rights or rights of the individual, should assess the implications of violation of these principles. Now, in view of the history of Ukrainian independent state, historical context and threats that it faces because of the temporary occupation of parts of its territory, Ukraine has the right to protect constitutional principles, including through the prohibition of propaganda of totalitarian regimes. The CCU also speaks about the truthful democracy as part of the joint legacy of the democratic nations. In 2022, the Constitutional Court underscored that pursuant to the Constitution of Ukraine, the state should implement in its activity the constitutional principle of its responsibility to individuals and the principle of bona fide governance. That is the commitment of the state to implement the polymodal foundations for the implementation of the state power to strengthen true democracy, human rights, and the rule of law as the actual European values. The Constitutional Court also looked at the issues of a rule of law and direct democracy, thanks to which it developed a number of its legal positions. And the decision of December of 2022 underscores that the fundamental value for a democratic state is freedom. So summing up this very brief overview of the legal positions of the CCU versus democracy, I can say that democracy is a key democratic value and its implementation demands the constant intellectual work to address the current challenges of the day. So I wish all of us a fruitful discussion, and may I remind you of the time frames: 20 minutes for the keynote address and up to 10 minutes for interventions by other speakers. And I would like to introduce our first speaker. The Constitutional Court is of the position that one of the fundamental principles of the rule of law is the principle of fair trial. So it is my great pleasure to introduce our first expert. This is Carolyn HAMMER, ODIHR Rule of Law Advisor. Ms. HAMMER develops and implements a number of bilateral and multilateral technical assistance measures and capacity building for the 57 countries that are state participants of OSCE. She has more than 15 years of experience of analysis of legislation in the sphere of democracy and rule of law. She also participated in the OSCE missions in Ukraine and Kosovo. So she will speak about the role of constitutional justice in strengthening democratic institutions, respect for human rights and the rule of law in the OSCE region. The floor is yours. We cannot hear you. Ms. Hammer? Ms. Hammer, we cannot hear you. Sorry, Ms. Hammer, we cannot hear you. We cannot hear you, Ms. Hammer. Could you please start from the beginning? We cannot hear you, unfortunately. We've got a technical glitch here. Sorry, we cannot hear you. We cannot hear you.
Hear me now?
Yes, we can. Thank you. Yes, wonderful. Thank you.
Thank you very much. Dear judges, dear expert participants, my name is Carolyn HAMMER, and I represent the OSCE Office for Democratic Institutions and Human Rights, where I work as a rule of law advisor. On behalf of ODIHR, I would like to express my gratitude to the Constitutional Court of Ukraine for the invitation to appear here today. It is an honor to be able to address you on the 27th anniversary of the Constitution of Ukraine. It is also a pleasure to be able to contribute to the very valuable work of our colleagues from the OSCE Support Program for Ukraine. ODIHR is the human rights institution of the Organization for Security and Cooperation in Europe. Based in Warsaw, Poland, ODIHR is active throughout Europe, the Caucasus, Central Asia, and North America. The office provides support to the 57 participating states of the OSCE in meeting their commitments in the field of democratic elections, respect for human rights, tolerance and non-discrimination, and the rule of law. Following the Russian Federation's military attack and its devastating consequences for the civilian population, ODIHR has made and will continue to make every effort to deliver both needed and timely support to Ukraine. The cornerstone of our work is a firm belief that lasting security cannot be achieved without respect for human rights and functioning democratic institutions. Constitutional justice, in particular, plays a crucial role in strengthening democratic institutions, ensuring that human rights are respected, and in safeguarding core rule of law principles. Constitutional courts are key actors in helping ensure fulfillment of obligations under international law, including under international human rights law. Effective constitutional review carried out by independent and impartial courts also helps to ensure the functioning of checks and balances between branches of state power and ultimately the conformity of state actions with rule of law principles. During times of conflict and emergency, this task, of course, can become even more difficult, even as the impact of the manner in which it is carried out can seem to be further reaching and to have wider effects. I would like to share just a few reflections on some of the challenges and good practices that ODIHR has noted in our work with respect to constitutional justice across the OSCE region, and to point to some areas where I believe that the joint work of national institutions and ODIHR can be particularly effective in overcoming these challenges. The first of these is with respect to the functioning of courts during times of conflict and emergency. As I have already mentioned, the administration of justice during times of conflict and emergency has posed and continues to pose specific challenges for many OSCE participating states. OSCE participating states have agreed that states of emergency may not be used to subvert the democratic constitutional order, nor aim at the destruction of internationally recognized human rights and fundamental freedoms. This was in 1991. Here, I would like to acknowledge the scale of the challenge that the judiciary of Ukraine currently faces in the administration of justice as a result of the Russian Federation's military attack on Ukraine, and to commend the ongoing commitment of judges and court staff to upholding their duty to advance the rule of law through their work. ODIHR values our own ongoing cooperation with the judiciary of Ukraine in assisting in training judges, prosecutors, and other Ukrainian legal professionals working on war crimes, while also administering justice during the armed conflict. We also witnessed that during the pandemic, states of emergency were introduced de jure or de facto in many OSCE participating states. We also witnessed some worrying instances when national parliaments or constitutional courts had to stop their work during the pandemic. This affected the effective oversight of the executives by parliaments and courts, and limited effective access to justice. We saw that some constitutional courts took the welcome step of assessing the proportionality and necessity of emergency measures and their compliance with constitutions. Here, I may make reference to the policy brief, which ODIHR has published in 2021 on ensuring the right to a fair trial during public health emergencies specifically. Next, I would say just a few words about constitutional justice and judicial independence. I would like to stress that another challenge that is present in many OSCE participating states, and this is with respect to interference with judicial independence. Across the OSCE region, we see many examples of executives attempting, and in some cases succeeding, to control the appointment, promotion, and sanctioning of judges with an ultimate goal of influencing the decisions of courts. This is happening despite clear provisions in the constitutions of OSCE participating states regarding the need to respect judicial independence. Here, I would like to underline that OSCE participating states have pledged to ensure that the independence of the judiciary is guaranteed and enshrined in the Constitution or the law of the country and is respected in practice. The Copenhagen document of 1990 also mentions that an inherent ingredient of the rule of law is the duty of the government and of public authorities to comply with the Constitution and to act in a manner consistent with the law. This shows that there is a great need to increase international cooperation and to consolidate our democracy and protect this key element of the rule of law, the independence of the judiciary. With this aim, ODIHR has developed a practical tool for how to ensure the independence of the judiciary. It is a point of pride that ODIHR's guiding document on this topic is named after your capital city. The key recommendations on judicial independence in Eastern Europe, South Caucasus, and Central Asia are named in that way because they were deliberated at an expert meeting in Kyiv in 2010. The key recommendations have guided the development of multiple pieces of legislation and rules on the work of councils for the judiciary, as well as procedures of selection, appointment, promotion, and sanctioning of judges across the OSCE region. The key recommendations have also served as the starting point for a set of additional recommendations which ODIHR will publish on these and emerging topics in the field of judicial independence. And here I would also like to mention that the involvement of experts from Ukraine in the development of ODIHR's recommendations has been very significant and in fact instrumental. ODIHR also has a well-developed methodology for the monitoring of judicial appointments in order to contribute to increased transparency, accountability, and fairness of the procedures to appoint judges. This methodology has been employed in our monitoring of the appointment of Supreme Court judges in Georgia, and it's now being used in the monitoring of the process of pre-vetting of candidates for the judicial self-governing body in Moldova. Should Ukraine wish to draw on our expertise, we are willing and able to offer you support. I would like to say just a few words about constitutional courts and access to justice. Another one of the challenges that ODIHR has noted with respect to constitutional justice across the OSCE region is the need to adequately ensure access to and the accessibility of these processes. It has already been mentioned, and of course we also know that the accessibility and transparency of constitutional justice is directly linked to public trust and confidence in the judiciary as a whole. Here, I would like to commend the OSCE support program for Ukraine in the work they are doing in this regard, and to express ODIHR's willingness to further support any efforts in this area. ODIHR continues to follow the developments surrounding the Constitutional Court of Ukraine with great attention. ODIHR attaches high importance to the mandate of the Constitutional Court of Ukraine to ensure the enjoyment of fundamental rights and freedoms by ruling on the constitutionality of laws and by hearing individual complaints. ODIHR has a mandate and a history of offering support to processes of reform of constitutional courts. I would also like to mention the special mandate that ODIHR has to review legislation, including draft laws, as to their compliance with international human rights standards and OSCE commitments. There is a rich history of cooperation between Ukraine and ODIHR in the area of legislative support. ODIHR has contributed to several joint opinions with the Venice Commission on the request of their Verkhovna Rada. ODIHR welcomes the opportunity to continue our long-established and fruitful cooperation with Ukraine's institutions and with civil society. Thank you very much for your attention, and I wish us very interesting and productive discussions throughout the conference today. Thank you.
Thank you, Ms. Carolyn, for your contribution to the support of constitutional justice and for your intention and willingness to continue to provide the support, and special thanks for, despite a difference in time, we know that you connect from the United States and there is nights there. You found the opportunity to connect and to support us with your presentation. As you noted, a significant role played by the Constitutional Court of Ukraine during the war. And I'd like to pass the floor to the next speaker, Ms. Vasyl LEMAK, the charge of the Constitutional Court of Ukraine, Doctor of Legal Sciences, Professor, member of the National Academy of Legal Sciences of Ukraine. The topic of his presentation is Constitutional Power in the Conditions of War, First Lessons of Ukraine. Please, the floor is yours, Vasyl. Good morning, dear friends.
Morning, dear friends. I'm very glad to see those who I've met before the international conferences, and I would like to congratulate you all on the 27th anniversary of Ukrainian Constitution. I will start my brief introduction, or say intervention, by mentioning that the war started in Ukraine 9 years ago, and the all-out war began a year and 6 months ago. And we are operating under totally new conditions, in a totally new context that urges us to look at the world in a different way. We don't know what awaits us, nor do we know our future. We believe we have faith in our victory. And even now, once the first stage of the war is over, we can make certain conclusions. And I would like to share my considerations with you. The first of them being that the constitutional democracy has survived in the first period, the most difficult period of the war. And we can say that now, the aggressor attacked Ukraine 9 years ago and launched the all-out war more than a year and a half ago. The aggressor is a huge country, and their values are totally different from those that we are guided by. And the Ukrainian constitutional democracy has stood the impact of this aggression, and we can see that we can prosecute this war against this huge aggressor country. So how can it happen? And I would not be speaking about all of the constitutional democracies that withstood the first impact of the war, but it is not the case with Ukraine. We have withstood this impact. We have got parliament, we have got the president and other legitimate constitutional institutions that have proven to be functional, to be viable. On the very first day of the large-scale invasion, Kyiv was bombarded, but it did not prevent us from invoking constitutional mechanisms of introducing martial law. The parliament had its plenary session, and they took the necessary steps to launch totally new mechanisms underlying the operational constitutional government in the conditions of the war. But that was not always the case. I would refer you to the 1940s in France when Germany invaded via Belgium to France. It also occupied other countries, but the constitutional democracies crumbled then, and the democracies that underlie the French, or the institutions rather, that underlied the French state of that day, betrayed the constitutional values while agreeing to capitulate, agreeing to give way to the dictatorial mandate of the new government. And we are proud that in Ukraine, it is not the case. The key issue, the key challenge is the capacity of our constitutional institutions and the support of the entire system of power. The doctrines that the world has developed over the last 200 years are well known. The democracy that is capable of protecting itself, that's doctrine number one. Another is that constitution is not a pact for suiciders. I can see Oleksandr Tanaso amongst the participants and speakers of this conference. Moldova was the first country to say that nothing in the constitution can be interpreted to the effect that the state can crumble because the president, for example, fails to perform his or her duties. From the very beginning of the war back in 2014, February 2014, Ukraine has faced this threat of collapse under the bombardment of the aggressor. We failed to understand many things back then, but when we saw the aggression in Crimea, where the capturing of a number of facilities in Crimea, the majority of the cabinet of ministers members in Crimea disappeared. Other institutions failed to operate, and Ukraine was on the brink of collapse. However, even under those conditions, in late February 2014, Ukrainian parliament took very correct decisions. Perhaps they were not based on written statutes. We didn't have the president, right? He fled. And they, some people criticized this for actually stripping him of his powers, but the parliament took decisions that are reminiscent of the Jefferson's ideas. Back in 1883, in one of his letters to a friend, he wrote, the following of the written statute is a high obligation of a good citizen, but not the highest one. The law of the self-preservation and protection of our country under the threat is of a higher nature. Losing our country through following the written statute would mean losing the law, the statute, together with the life, freedom, property, and everything that we are enjoying right now. So you can lose a country if you abstain the position that a certain written norm can prevent you from defending your country. So the Constitution is not a pact for suiciders. And I would interpret Jefferson's quote in the following way. The law should be effective during the war, but the written statute should be interpreted in the context of values. And each of the countries of today promotes the values of democracy, human rights, and a rule of law. And there are other values like national sovereignty, independence, territorial integrity. So the constitution from the very first days of the war demonstrated that we still lack some procedures in order to properly protect constitutional institutions in this country. Yeah, it's only vis-a-vis parliament that its powers are clearly outlined, but the law keeps silent with regard to the role of the president or the justices of the constitutional court in the times of the war. Our constitution contains some safeguards related to the martial law. I will mention just one of those. The constitution cannot be amended during the martial law. My interpretation is broad of this very provision, not only amendments to the constitution are allowable during the war, but amendments to other laws should not also be supported. The aggressor will only agree to withdraw from the territory of the aggressed country once it changes its constitution. Here I refer to Finland and to Austria that was forced to revise their constitution to introduce their neutrality status. For Ukraine, it is unthinkable. And there is an issue of a democratic oversight of the military authorities. And it is the courts that have an important role to play here. Our constitution and our martial law legislation are clear here. The right to fair trial cannot be limited. Now to the lessons learned over this year and a half. The lesson number one is as follows. We have to preserve and enhance constitutional institutional capacity of all organs of all authorities. When it comes to CCU, its daily effective operation provides presumption of constitutionality of all pieces of legislation gearing towards the successful prosecution of war by Ukraine. Lesson number two, the experience of democratic state shows that the work of constitutional institutions in the times of war should be proactive rather than reactive. And the key state programs related to the martial law, major acts of legislation should be adopted well in advance. Not only does it concern the amendments to the criminal code, but also the programs of engaging the society into the evacuation, into standing up to other threats. Lesson number three, separation of powers is essential, particularly at the time of war. It's not a technical matter. We are here speaking about the balance of powers in the times of war. It means that there are certain red lines that cannot be trespassed for the powers that be to remain within the constitutional framework. No one, even during the war, cannot replace and substitute parliament in adopting laws. And there is another red line. Parliament and executive branch cannot take decisions to substitute for the judiciary. So these two things are essential, in my opinion, for the balance to be preserved. And to end, interference into human rights that is necessitated by the times of war should not be arbitrary. It should be based on clear and rules, preferably on the norms of the law. They should be reasonable and proportional at any time, both in the narrow and in the broad meaning of the term. And lastly, courts in the times of the war need to operate to their full capacity in terms of protecting and promoting human rights, and they should exercise restraint all time. So in courts now, we have several cases appealing the orders of the military authorities. So courts should exercise caution here. The commander's orders should be revised only when it comes to the protection of human rights and fundamental freedoms. Never should courts undertake to resolve certain practical matters of the war prosecution in the country. Glory to Ukraine, glory to the heroes. Thank you very much for your presentation. The constitutional democracy in Ukraine has indeed withstood the impact of the aggression because we are guided by one goal, and that is European integration of Ukraine. Thus, I give the floor to Mr. Oleksandr VODIANNIKOV, Senior Project Assistant of the OSCE Support Program for Ukraine, and he will be speaking about democracy, constitutional European integration in the context of models of constitutional accommodation. Thank you very much. It is easy for me to start this intervention because a lot has been said about the war, about post-war vision of this country by the previous speakers. And that makes me very glad that we are thinking about the post-war future of this country that is closely related to European integration and our membership of the EU. The values that we've been discussing and will be discussing today, as Pierre said, are common values, common European values in the broadest meaning of the term. But I would rather focus on a narrower topic that is related to constitution and European integration. Next slide, please. European integration is important. We do meet the Copenhagen criteria, and the accession negotiations are to start soon. The process is fairly complex and serious. There were countries in the history of the EU that managed to go through this process within 3 years, and that's Lithuania and Latvia. They put in a lot of effort. Besides, they had political and societal consensus within those countries. We can follow suit, but for that we need to ensure that the society and political class are all consolidated to adopt the body of European law that any candidate state should have in place. But that does not mean that these issues are beyond constitutional law and constitutional order. Now, the constitutional integration preceding the accession, during the accession, and post-accession pose a serious challenge to any government. So now we have to start thinking about very important issues, how to define the correlation between the constitutional order and the EU acquis. What are the constitutional limitations in the context of accession? How can the constitution regulate our membership of the EU? And we should address the issue of the model of adjustment or accommodation towards our potential membership, and what changes should be introduced into the constitution. Why are we asking those questions of ourselves? Next slide, please. we should understand two key functions of the Constitution and their impact in the sphere of European integration. First of all, it is the enabling function. Constitutions establish institutions that exercise public power. They describe their mandate. In the sphere of European integration, that function presupposes the models of limiting the sovereignty or delegating certain sovereign powers to the European institutions. And most of the European constitutions have those European clauses to perform this function. And the next function is the limiting function. A function of limiting powers through the separation of powers through respect of human rights and fundamental freedoms. And there are new limitations that are inscribed in the principles of the national sovereignty, democracy, and the constitutional order itself. At this backdrop, let us look at the EU acquis. There, indeed, we will find this principle of constitutional identity versus the principle of the prevalence of the EU law. Treaties, in particular, Part 2 of Article 4 of the EU Treaty establishes the obligation to follow the constitutional values and constitutional identity. At the same time, there is this fundamental principle of the prevalence of the EU law. The member states cannot rely on the constitutional provision when it comes into conflict with the EU acquis. And the EU court stated that the norms of the national law, even the constitutional norms, cannot undermine the effective EU law. And the second principle is that of the autonomy of the EU law, and they are extrapolated upon the right that the CCU will have after or following the accession. So this should be defined in accordance with the EU acquis, and the judges will of the EU will have of the EU court will have exceptional powers there. How to address this collision between the national constitutional order and the EU acquis? At the abstract level, we can be speaking about several models of accommodation. Just like with Belgium, the Netherlands, and Denmark, and the Dutch president is very interesting about the constitutional agreements, given that there would be the qualified majority in parliament.
A limited sovereignty regime implemented in France in 1992. And then after Maastricht, changes were made to constitution. The regime of delegation of sovereign powers, the German model, the joint implementation of powers regime, and special constitutional regime in Ireland, Austria, and Estonia. Estonians did not change their constitution when joining the EU. They adopted the Constitutional Act, the Statutory Act on accession to the EU. It's a separate act that has constitutional significance in addition to constitution. What is the model suitable for Ukraine? How the states resolved at the level of the constitution and the issues to become part of the EU law on one hand, and on the other hand, to implement EU law into their legal systems. We can have three key provisions included into constitutions. Not all constitutions contain all three provisions, but the main clauses are European clauses, Europe's clauses, where in constitutions it is envisaged that the country becomes EU member to achieve the objectives of EU. Then, depending on the specificities of constitutional order, at the level of the constitution. Some basic issues of membership in EU can be settled, like election to EU Parliament and European arrest warrants, appointment to the European Commission, and so on. And the majority, the 24 countries have special powers on transfer of powers. The provision on transfer of powers to the European level. Next slide. Going back to Ukraine. In 2019, we amended the constitution to record the European vision, our movement to the EU, and in my view, it was a very significant, decisive step in this direction. Indeed, these changes determine the current process, and the beginning of negotiations is part of this constitutional framework. It is also determines the European identity of Ukrainian people in preamble. As you know, preamble identifies the context of interpretation of constitutional provisions. But we have the issue due to European integration process. What changes should be made to the constitution going forward to avoid collisions? The Ukrainian constitution is based on supremacy of constitution. International treaties have lower priority compared to constitution. When we join the EU, we will have the issue. Do we implement the European provisions the way it was done by the majority of countries recently, the countries that joined to the EU recently, or do we have special provisions related to the membership? Do we need to make clauses on delegation of some powers to the European level, to the level of EU? This is difficult matter and important matter, as the experience of other countries shows. These debates were carried out for years there. As a result, all countries acceded to the EU. Although we expect the beginning of negotiations, even now, we have time to start some expert discussion on amendments needed for our EU integration process. Thank you for your attention. Thank you, Oleksandr. Indeed, you touched on a very important matter. It is the vision on the future balance between constitutional identity and the primacy of the European law. And it is very important for us to start this discussion and discuss the appropriate points. And you made the right emphasis that the example of our friends, Latvia and Lithuania, is very inspiring on joining the EU. But not only Lithuania and Latvia, also the experience of Poland, our neighboring state, great friend of Ukraine, is very important for the development of landmarks for Ukraine to move to the EU accession. So I pass the floor to a great friend of Ukraine, the charge of constitutional, the special advisor of the Constitutional Court of Ukraine, professor, head of Department of Constitutional Law of the University of Colonel Stefan Kuczynski, the charge of the Constitutional Court of the Tribunal of the Polish Republic, retired Mr. Miroslav Granat. The topic of his presentation is responsibility of constitutionalism for the future of the state and society. Please, Mr. Miroslav, the floor is yours. Yes, loud and clear.
Many thanks for your invitation. This is the pleasure to meet you. I know that we work during the time of the war, and this is extremely difficult situation. And I know that the Ukrainian people defends the liberty, defends the Europe, and among other, my country. So I would like to stress at this moment that Poland supports Ukraine in the unwavering way, unwavering manner. And secondly, I would like to greet all people, all participants at the seat of the CCU, remote participants. Especially I would like to greet Mr. Serhiy HOLOVATY, acting president of the CCU, all Ukrainian colleagues, judges, professors, participants. I hope that maybe next year we will meet face to face in Kiev or in Warsaw. So I will prepare a few words concerning my topic. I think about the responsibility of constitutionalism for the future of the state and society. Constitution as basic laws bear a great responsibility for the future of the state and society in every country. It's concerned Poland and Ukraine too. Certainly, this is also the case with the constitutions of our countries. So I would like to say a few words about such responsibility with regard to the 1997 Constitution of Poland. Our constitution is younger than your constitution, but this is only 1 year. I think that many of these remarks will also be relevant for the 1996 Constitution of Ukraine in the day of the Constitution. So, as regards me, there is no doubt that there are 3 most important constitutional values. Those are human dignity, the common good, and human rights. In the Constitution of Poland, these values are also its main principles of law in the Constitution. So here we deal with not only great value, but also with specific legal provisions. They form, according to my approach, they form the basis of the Constitution's responsibility for the future of the state and society. Obviously, here it's not possible to discuss in detail each of these values and principles of law. This is beyond the scope of my talk. However, invoking them here will make us aware of the responsibility of constitutionalism for the future. And firstly, as regards human dignity, much has been said in the literature about human dignity. Here, I would only like to add that in the Constitution of Poland, human dignity is expressed in a particularly profound way. So I think that our approach in this field is deeper than, for example, Article 1st in the German Foundation Law or maybe in the European Chart of Human Rights. So according to our Article 30, human dignity is the foundation of the entire constitutional state system. According to me, this is quite a unique approach. It is the primary constitutional value, and at the same time, it is a subjective right of every human being. As a value, it is situated above the law, obviously, it is clear, but at the same time, it influences the law. For example, under the Constitution, it is a source of human rights in Poland, according to our Article 30. And human dignity is also a subjective right used by the courts, which serves every human being. For example, the Constitutional Tribunal found that the statutory provisions which allowed people to be evicted from their flat to the street deprived them of their dignity. Dignity as a subjective right is so strong that when it comes into conflict with another right, it always wins. Human dignity always wins during the clash with the other value or other constitutional rights. The prohibition of violating human dignity is absolute. So, secondly, I want to go to next constitutional value, I think about the common good. Common good, this is value quite specific for Polish constitution and for Polish approach to the state as Rzeczpospolita, as Republica, but according to our legal doctrine, the term Rzeczpospolita is a quite specific notion. So, pursuant to Article 1 of the 1997 Constitution of Poland, the Republic of Poland is the common good of all its citizens. This is the sense of Rzeczpospolita. The principle, due to its primary and fundamental substance, cannot be defined by us, by legal doctrine, by judiciary. In any case, this is not my purpose here. I would like to show the common good as a kind of bridge between the present constitution and its future. The principle of common good can play the role of a bridge between the present and the future for several reasons. Firstly, the role of common good is manifested in finding the balance between an individual and society on the basis of the law in force. In the case law of the Constitutional Tribunal, the common good is not associated with, for example, the interest of the majority, the interest of the general public, or with the state. In a particular legal dispute, the common good may not be on the side of the state or some majority, but on the side of an individual citizens. And we have a lot of examples in our judiciary, especially under the functioning the tribunal before 2015. Secondly, the common good is related to the principle of human dignity. It is impossible to imagine a republic, I use the Polish term Rzeczpospolita, which would be the common good and at the same time would violate human dignity. If the law expresses the common good, it also expresses the recognition of human dignity. The common good is not opposed to human dignity. These values do not compete with each other. Thanks of the principle of the common good, we can see human dignity not only from an individual, but also from a social perspective. Through the principle of the common good, we can show the social conditions in which human dignity can be preserved. And finally, I want to say a few words concerning human rights as a third main value in our constitution and as the bridge for the future. So in the Constitution of Poland, human and civil rights are understood as manifestations of human dignity, or in other words, human dignity is the core of human rights. We can better understand human dignity if we express it by means of freedoms and rights. So dignity can be compared to a tree with human rights at its branches. Dignity thrives in human rights, which means that it is the fundamental reason for their expression and defense. Human rights are inalienable because they embody human dignity. Under the Constitution of Poland, human rights are inherent. Obviously, this is the same like in Ukrainian fundamental law, German fundamental law. They are not granted by the government. Next, human rights are universal. They serve every human being and inalienable. They cannot be renounced or taken away. Finally, human rights are inviolable, which means that the state cannot abolish human rights. And to sum up, we can see that the three main constitutional values, human dignity, the common good, and human rights, which also take the form of principles of law, are closely interrelated. Each of these values determines another one. It is thanks to these values and principles of law that constitutions endure over time. Thanks to them, constitutionalism can bear responsibility for the future of the state and society. Obviously, a necessary condition for the functioning of constitutionalism, however, is the preservation of peace. Then human dignity, the common good, and human rights can be realized. In the same way, our considerations of constitutionalism make sense in the situation of peace. And we wish you the victory and the peace in Ukraine. So thank you. Thank you once again for your attention, and thank you once again for your invitation. Thank you.
Thank you, Miroslav. We do agree that human dignity prevails always, and we hope for the very soon victory of Ukraine, and we hope that the next Constitution Day will be celebrated in peaceful Kyiv. Mr. Miroslav Granat, in his intervention said that democracy is inseparable from human dignity and human rights. So we cannot speak about democracy separated from other constitutional values, and the importance thereof grows during the times of the war. And I will give the floor now to Olena Borislavska. She's professor of the Department of Constitutional Law, Ivan Franko National University of Lviv. She is chief co-editor of the Ukrainian Journal of Constitutional Law, doctor of law, and professor. She will be speaking about democracy and its correlation with other constitutional values in the context of war. Thank you very much. First of all, I would like to thank the organizers of the Constitutional Court of Ukraine for the opportunity to speak to you and share some of my considerations on this solemn day, which is particularly remarkable and symbolic in the times of war. I would like to start by saying that despite the war, Ukraine continues to implement the triad of constitutional values, the values that are common for European countries, but they are being implemented in Ukraine, alas, in the context of the all-out war that has been waged against Ukraine for almost 500 days now. That means that we are facing the challenges and problems that do not have resolution so far. They are absent from the acts of the European acquis, in the case law of the European Court of Human Rights, and the recommendations of the Venice Commission. That is the sources, the literature where we seek answers or responses to the questions we might have or challenges we might face. So in many respects, we are the pioneers here. Of course, human rights, the rule of law, democracy are not just common European values that Ukraine also espouses. It is part of our constitutional identity. And these are the things that should be specifically protected by the Constitution as the fundamental principles of the Constitution of Ukraine. But the war introduces changes not only in everyday life, but also in the perception and implementation of constitutional values. So the triad of common European values are willy-nilly affected by other values like state sovereignty, territorial integrity, and the national security. Hence, the question of the correlation amongst all of those notions or values. And it is not the matter of doctrine or theory, but rather of a practice of the large-scale active hostilities entailing casualties among civilian population, destruction of infrastructure, and other atrocious things. Of course, democracy remains for Ukraine and Ukrainians one of the basic constitutional values. At the same time, it is obvious that democracy is also a mechanism for the state to operate, to function. It is also a mechanism through which people interact with the state, with the government. The foundation for this mechanism lies in the elections. However, the Ukrainian legislation allows for the times of armed conflicts, wars, and emergency to have a pause in the electoral process. And again, The question is whether we are speaking about the state's derogation from democracy as a value. Well, that means that democracy ceases to be implemented as a value, whether the democracy is put on hold. I think that the answer should be sought in yet another question. What is the role of elections in any democracy? Of course, it is something more than just a way to shape the public authorities and ensure their accountability. It is also the way of manifestation of the rule of law, and at the same time, it is the source of democratic legitimacy. Are elections the only source of this democratic legitimacy, particularly when we speak about the times of the war? I would like to underscore that elections are the main source of democratic legitimacy. However, it is not the only one, as these times of the war have shown. There are at least two more such sources. First of all is the civilian oversight over the functioning of the public authorities. I mean the oversight by the civil society. This is the so-called participatory democracy, which is manifested at different levels, more evidently at the local level, but at the national level as well. So, harking back to the issue of elections under the conditions of the war and the threat to elections if they are held in these times. So we can see two such threats. First of all, these are security and safety threats to the voters themselves. I think it would not be justifiable under the current security conditions to organize elections, thus posing a risk to the population. Another threat is the undermining of the general societal unity. The political schism should affect negatively the defensibility of this state. I think that at times of war, the abstention from conducting the election, does not mean the lack of democracy or democratic legitimacy that I mentioned earlier. We should also remember about the important fact that the powers that be enjoy democratic legitimacy thanks to and until it is capable to prevent the deadly threat of the Russian aggression to the Ukrainian citizens and our statehood in general. Then to end, I understand that we've got very little time left and we still have two interventions to go. I would like to conclude that democracy as a value does not disappear, nor does it lose its importance in the times of war. It is implemented in a special way with due regard to the objectively growing importance of other democratic values dictated by the life itself. Thank you, Olena, for your intervention and for your very active support of the Constitutional Court in your capacity of the member of the expert board. I will give the floor now to Yuri Barabash, who celebrates his birthday today. Happy birthday to you, and the main wish is for us to celebrate the soonest victory. Mr. Yuri Barabash is Vice Rector for Research and Academic Affairs and Strategic Development of the Yaroslav Mudry National Law University. He is Doctor of Law Professor, and he will be speaking about the principle of separation of powers in the official constitutional doctrine, and he will elaborate on whether there is a room for independent agencies under the circumstances. Thank you very much, Olena. Every day I celebrate my birthday with my colleagues from the Constitutional Court, which I highly appreciate. I would like to thank the Constitutional Court for inviting me to speak on that day. If you could show the next slide, please. Thank you. I would like to discuss the following issues. Even though I would focus more on the principles of the law-abiding state or law-governed state and the issues that arise from the operation of the Constitutional Court of Ukraine. So I would like to shed the light on some matters that might go beyond the topic of democracy alone. First of all, I would like to focus on Article 6, and I do agree with Vasyl that separation of powers does not work as an axiom under the martial law. Even though it should not be revised under martial law, it still can be limited. The separation of powers was introduced in 1996. Before that, the Soviet system did not provide for the separation of powers. And in the declaration of the state sovereignty, there was even a referral or a reference to the prosecutorial power. And according to the decision of the Constitutional Court of Ukraine that concern the incompatibility of the work in parliament and commercial activities, and that the parliament should be professional, and we received independent and fully fledged lawmaking body. But back in 1998, when I started working for the academy, I saw the plaques on the courts, like local courts, and under that there was a line, Ministry of Justice in Ukraine. So the introduction of the notion of the separation of powers was the legislative novella back in 1996. Since 1997, though, the official doctrine was developed to single out in this triad the separation of powers. And we are speaking about three branches that are very well separated, which is quite right. At the same time, there are certain agencies that do not fall under those three branches of power, but they do perform very important functions of adjudication of justice or public administration. And that was mentioned in the case regarding the Accountants' Chamber of Ukraine. Another issue related to the interpretation of the separation of power notion is the judgmental categories when it comes to the definition of status and mandates of the subjects of power. So every time when we appeal to the doctrine of the separation of powers, we lean on the American theory of constitutional law and the law of public administration. But we should again exercise caution, because the strict separation of power can only function fully fledgedly in the presidential republic, where the president is the head of the executive powers. Then this system of checks and balances works well. But if we look at the Westminster system, where members of government are also members of the House of Commons, then this doctrine would be interpreted differently. When it comes to the head of state, then the mixed mechanism or mixed model affects the functions and powers of the president, particularly when we say that our president, Volodymyr Zelensky, undertakes great responsibility and he should have very clear-cut mandate. Our constitution uses a whole bunch of judgmental categories. First of all, the first formula that was borrowed from the constitution of the aggressor country, and the two latter positions are formulated as in Article 6. Not only are they specific mandates or powers, I do not support the doctrine of latent powers or authority. And I agree with Mr. LEMAK in that we should remember that Article 6 of the Constitution vests a number of mandates in the president in three major areas, and the Constitutional Court should keep that in mind. As it was done in one of the first decisions of the Constitutional Court. We do not usually quote rulings rather than decisions, but there is a whole set of rulings that are important. And there are two important decisions vis-a-vis presidential decrees, and they date back to 2009. The Constitutional Court insisted on several important things.
Повинно означати, що він повинен мати якісь важелі.
It should mean that the president should have some levers of influence. The person who manages national security cannot be limited by the arsenal which is envisaged by the law, especially under the martial law. I fully agree that as umbrella, we need to have the principle of division of powers and the legality principle, which is component of the rule of law principle. At the same time, the president has to have some levers of influence to implement, to execute his constitutional tasks, and Constitutional Court speaks about this, and this is quite reasonable. Next slide. Having analyzed different doctrines, I'd like to draw your attention to constitutional doctrine of Poland. And Constitutional Tribunal of Poland demonstrates its more liberal approaches. As Constitutional Tribunal says, we can also review this, and it can be beneficial for us. Given to the president some levers of influence onto the constitutional functions, and second, exclusively on the grounds of laws, is not only feasible, but also it is constitutional. I would like not to exceed my time. Next slide shows establishment of independent agencies. Now, we don't have time for this, and it's not the right audience to go into details, because I have many distinguished colleagues here. Some points, this is American doctrine that was initiated at the time of Great Depression, and Franklin Delano Roosevelt was trying to overcome, and to say that the state should think not only on big corporations, but about the people. It was implemented in practice of constitutional jurisprudence, and it envisages several details. They all are presented at the screen. The case Humphreys executive versus United States clearly says that when constructing any entities which are not envisaged by the Constitution. We need to adhere to constitutional guarantees, which ensure, first, the principle of division of powers, and second, the principle of legality in functioning of these entities. And the last slide. I borrowed this title, the President as the State Notary, from the former chairman of the Supreme Court of the Constitutional Court of Estonia. You know that Estonia has the system of constitutional control. The Supreme Court, as a chamber, in the form of its chamber, performs the constitutional control. So they recognize the president as the notary of the state, and the president acts in a certain way to guarantee the adherence to Constitution, at least when it doesn't follow directly. And the previous slide, there was a story of 2007 when President Yushchenko extended the interpretation of his powers under Article 102, and he disbanded the Constitution as the guarantor of human rights in the Constitution. When we analyze independent entities that the state tries to establish to fight corruption or to regulate some economic processes, we always appeal to the principle of division of powers. This is right, but at the same time, based on the constructs suggested in the law on some agency, we can evaluate how this step is constitutional or not. As an example, with no regard to independent agencies, I give the ruling from the Constitutional Court of Slovakia, where the president acts as the notary of the state. The government, through the parliament, offers the candidacy of the vice president of the National Bank, and the president says this candidacy is not in line with the law. The government was offended, and the Constitutional Court ruled that the president has the right for this, although this is not specified directly in the Constitution. The Constitution says that the president appoints officials according to the law. So in this area, it is the demonstration. We're not trying to find some hidden powers of president that are not written in the Article 106. There is attempts to demonstrate that evaluation constructs are used in the text of Constitution. They are not just empty words. Behind them, there is some meaning, which has to be determined by the legislator under the control of the Constitutional Court. If Constitutional Court follows this balance, then it ensures what we say about the Constitution as the living document, as the document which did not just stabilize some political order, but also it allows this order to develop. This concludes my presentation. Thank you very much. Once again, glory to Ukraine. I'm speaking from the city hero Kharkiv, and I wish you productive discussions. Thank you for this chance to participate. Thank you, Yuri Grigorievich, once again. Congratulations on your birthday. And Elena Borislavska mentioned in her previous presentation that indeed the NGOs and civil society organizations on the war play a very important role to ensure the principle of democracy in governance. And Constitutional Court of Ukraine, in its ruling of 2019 on September 6th, mentions that the NGOs are a natural foundation of constitutional democracy. And I invite the representative of the NGO, which is very important, the member of the governing board of the Center of Political and Legal Reform, the head of the projects on constitutional law, the co-chair of the Council on the Reanimation Package of Reforms, Ms. Yulia Kirchenko, who will talk on the review of democratic constitutions during the war in the light of European integration. Please, the floor is yours. Thank you. Thank you very much. Let's share my presentation. I'd like to thank Constitutional Court for invitation and cooperation with the Center of Political and Legal Reform. We value this cooperation, and we are ready to provide our independent expertise. The Center of Political and Legal Reform was founded in 1996 by Igor Kryushko, who is now he was the member of parliament who voted for constitution, and he felt the need to establish independent sense and to develop laws to implement the constitution. We continue this mission, and now during the war, the constitutional section is trying to do that. So I'm very grateful for this invitation, and let me start with the following. It's obvious to us that empire attacked Ukraine because Ukraine chose democratic development. Actually, the empire is fighting the democracy. So our position is clear based on our rule that when it's have victory on the battlefield, and I'm grateful to armed forces and citizens protecting us with weapons, and on the other hand, when it survive as democracy during the full-scale war and actual genocide of the Ukrainian people. I would like to make a short overview of some democratic institutions that would like to emphasize that we monitor to make sure we don't cross the line at some point. I'd like to remind you that on 24th of March, according to the Constitution, the martial law was introduced and we notified UN in due course that constitutional rights will be limited based on legitimate reason because of full-scale war. I'd like to remind you, maybe you have seen this sociological pool. Now, we didn't have these numbers before. According to the sociological pool, 95% of Ukrainians believe that Ukraine became fully fledged constitutional democracy. And let us quickly review the democratic institutions, how they operate under difficult conditions. The parliament. We have to give the due to the parliament. It's very hard for the parliament, based on the functions of parliamentarism, to operate during the war. However, they continue to function even during the first months. The leading role of the parliament, the MPs were convening regardless of threats to their life. What we see is plenary sessions are taking place, committees continue to work, decisions are approved. However, I'd like to draw your attention that we have analyzed with Vladimir Wenger, we do research the parliament under war. The parliament enhanced its productivity, but it's not expected. The trust on the martial law decreased. Only 29% of citizens mentioned that they trust in the parliament, only 29%. We believe what is the problem, in particular NGOs complain that the war is underway for a long time, but there is no agenda of the parliamentary sessions, and some NGOs in different areas which work, they cannot respond to the legal initiatives, and the information on the contents of parliamentary sessions and sessions of the committees is limited. And the last risk, I show it on the slide, and this provokes dissatisfaction of citizens, active citizens. Many people are not aware of this, and I will tell this now. We already have broadcasting of all sessions, so the plenary sessions of the parliament, they are uploaded about 1 day after the session with a delay on YouTube. You can follow this. Committees work differently. Some committees are open, some committees are fully closed, and we need to work together to have a unification. As a threat, next slide, please. The elections. We need to hold elections, but the trust in the armed forces of Ukraine, this is very positive during the war, but the issue is how do we update the next cooling of the parliament, next composition of the parliament. One of the lead roles of the parliament is in Eurointegration, harmonization of the legislation according to the EU acquis. Let's discuss elections. We need to talk about elections now. We need to think about elections. We don't raise the issue that elections can be carried out during the war. doesn't mean the destruction of democracy. We understand that according to the calendar we have on 29th of October this year, we have to have parliamentary elections. We understand that even if the war finishes in some miraculous way, now we will not be able to hold elections on October 29. This is not possible. And the terms in the election codes are not realistic, and the next parliamentary election and then presidential election, they will be done based on special law. And what are the main threats? The time and method of conducting the next elections. There is issue if the election system, if Ukraine can perform it after the war. The elections after war will be special, but we need to ensure the implementation of active and passive rights to all citizens of Ukraine, regardless of where they are. The IDPs or people who are forced to go abroad. So this is very important to get the legitimate election and the legitimate composition of the parliament. And the scale of voting in the occupied territories, some limitations. Well, the old occupied territories and preserving democracy. This is preserving democracy and not how it may be interpreted by the aggressor country. This is not 1 or 2 years. This is a greater period of time to be able to restore and to hold democratic elections, to restore the freedom of speech and our television. What is interesting here, in the Sectoral Election Commission, we're looking for the ways of conducting post-war elections. We had a conference with the European Parliament. The issue was raised, maybe it's the question to Constitutional Court. It's the issue of voting abroad. So because of a great number of people, we cannot ensure this through the diplomatic institutions, because people will have to wait in queues for months because there are millions of them. The issue is how to do it overseas, and we have resources, time, and we can do early elections for voters abroad. Many people say this is unconstitutional because our constitution establishes a clear day of election for the parliamentary election and presidential election. The day of election is not the day of votes. And also in the constitution of Estonia, it also establishes the day of election, but there is also early voting and no one puts it in doubt. And so I found out that most opinions of the Central Election Commission say that this is unconstitutional. Presidency. The president of Ukraine. It's the individuality that inspires as the commander-in-chief with extraordinary powers during the martial law. But I'd like to note about some concerning signals, not now, but after the end of war, after our victory. In our view, there is high concentration of power and excessive dependence on one individual in the state, and there is major political influence of the office of the president. The office of the president is the institution without constitutional anchor, but now it's very influential in Ukraine. We need to review this, to rethink this, to make sure that we have the appropriate status of democracy. Constitutional Court, it is necessary to mention this. Constitutional Court also is the collective body, did not stop its activity when the full-scale war started, and it continues to perform its constitutional functions. For us, it is extremely important. Thank you for working in this difficult period of time. We have to mention that over 2022, since April 2022, this is our data from open sources. hopefully they comply with reality. The Constitutional Court made 829 rulings, 46 resolutions, 13 decisions of the court, 4 decisions by Great Chamber of the Court. I'd like to know that Constitutional Court, under these conditions, carries out hearing in the open format. There's oral hearings, and it's very important. They invite independent experts, and the main challenge we see is the work of the Constitutional Court is very complicated because of 5 unfilled vacancies. However, we do not call the government to fill them immediately, because first we need to fulfill the first recommendation of the opinion, which says that vacancies have to be filled through competitive selection. And now the draft law in the parliament, where support is, and we expect the approval and proper filling of vacancies. The last slide. The judiciary system, let's omit this. There are major challenges, but we'll omit this. Media and the civil society. The control from the civil society did not stop. We even have many more new NGOs that work as volunteers, and they perform oversight over governments. We have serious democracy despite the war. There are no attempts from the state to discredit civil society, to stop civil society media. This is important. We have limitations during the martial law. We have unified marathon, unified news, which limits competition between the TV channels, but we believe this is feasible and proportionate during the war, but we need to fully stop this after the end of war. We need to say that we need to go back to the freedom of speech. Thank you very much for your attention. Thank you, Olha. Thank you to all speakers. We're behind schedule. I pass the floor on moderation of our event to Serhiy. This is a technical announcement. So everyone is going forwards. We also have speakers online from overseas. Unfortunately, we have to announce break for 10 minutes. And we will have coffee and lunch and everything, but we go back at 13:30. We will start our next session according to the agenda.
Я звертаюсь до всіх наступних промовців.
Dear colleagues, dear speakers, we have got a lot of presentations and interventions, and I call on you to keep within the time limits allocated to you. 20 minutes for the main presentation and up to 10 minutes for the intervention. The moderator of this session on human rights that we've touched upon before while speaking about human dignity as a source of human rights will be Oleh Pervomaisky. He is Justice of the Constitutional Court of Ukraine. So over to you. Thank you very much, esteemed Chief Justice. We continue working and we will be speaking now about human rights. And it is my great pleasure to give the floor to a judge of the European Court of Human Rights in respect of Ukraine, Mykola Gnatovsky. You all know him very well, and it is but natural that he has been elected the ECTHR judge. He is very well experienced in the sphere of human rights. He will be speaking about Constitutional Court of Ukraine and European Court of Human Rights, distribution of roles in ensuring the protection of human rights in Ukraine. Yeah, we haven't got the connection, unfortunately. No, I'm here. Yeah, thank you, that's great. I've introduced you and I've also introduced your topic. Thank you very much. Thank you for the introduction and for inviting me to speak on such a wonderful and important day for Ukraine, the Constitution Day. Dear Mr. HOLOVATY, dear justices of the Constitutional Court, esteemed colleagues, I think that today is the day when we have a wonderful opportunity and occasion not only to celebrate the Constitution Day, but also to discuss very specific matters that are supposed to help us all in do our work to the utmost capacity possible. And I will now transfer to the subject matter of my presentation in order to leave some time for the reflection and feedback. So, the main premise that I would proceed from is that the Constitutional Court of Ukraine is a key institution in ensuring the respect of human rights in our country. In this sense, its role is fundamental. You know fully well that the European Convention on Human Rights and the operation of the ECTHR are based on the principle of subsidiarity, according to which the primary role in ensuring respect of human rights, the primary function of meeting all of the challenges posed by potential violations thereof belongs to the state. It is up to the state to work on that day and night. The ECTHR has only an additional subsidiary function, and only those cases that cannot possibly be addressed at the national level that go to that court. Whenever there is a need for this international judicial authority to state its position about the protection of human rights or the failure to do so. The concept of subsidiarity has been used by the European Court for quite a long time, but with the advent of Protocol 15 to the European Convention of Human Rights in August 2021, this principle has been incorporated into the preamble of the European Convention. In the same token as the European and European Atlantic choice of Ukraine became part of the preamble of the Ukrainian Constitution. And I heard Mr. HOLOVATY comment on that in his introductory comment. And we have to take this principle while interpreting the Constitution of Ukraine. So the fact that the subsidiarity principle and the notion of the margin of appreciation is part of the preamble of the European Convention is quite natural, because the court has always been using these notions in its operation. When the protocol took effect, Protocol 15 took effect, the court started responding in the most serious way to these categories, underscoring the primary role of the state and underscoring its subsidiary function, underscoring that the national courts have a key role to play. And here I would like to hark to the discussion that was actively underway amongst the Ukrainian constitutionalist lawyers and practicing lawyers when back in 2016 amendments were introduced in the Constitution of Ukraine, and the constitutional complaint notion was introduced. At that time, a lot of our colleagues argued quite reasonably that now, thanks to this, Strasbourg will be located in Zhelenska Street at the address of the Constitutional Court of Ukraine, whereas the Constitutional Court will have to undertake the functions of the ECTHR, of the Strasbourg Court. It might seem banal, but nonetheless, it is as cute as before that post-Soviet countries have wonderful courts that adjudicate commercial disputes in London and wonderful criminal courts located in Strasbourg. It is a joke, but still a very legitimate one. At the very beginning of the introduction of the constitutional complaint and the legislative regulation in the law on the Constitutional Court of Ukraine, we used to have a lot of discussions amongst professionals. Then the pandemic ensued, after which the large-scale intervention or aggression of the Russian Federation against Ukraine followed, let alone the turbulence of a different nature that was not very instrumental in the operation of the Constitutional Court, where it concerned the constitutional complaint. Nonetheless, there is potential for a proper consideration of constitutional complaints. From the perspective of the ECTHR, it is important to establish the moment when the constitutional complaint can be considered an effective remedy, the exhaustion of which will be required according to Article 35 of the European Convention on Human Rights, and the existence of which flows from the entire logic of the European Convention, in particular Article 13. So the European Court of Human Rights has very well understood and developed criteria in the cases regarding a whole set of other countries. In particular, I should refer here to the decision of the Grand Chamber of the European Court in Zoom versus Turkey of 2013. It was the simplest way to formulate such criteria, I think. And I hope that in Ukraine, the situation would change in that these criteria will be met fully, and citizens, individuals will have the opportunity to file such constitutional complaint when their human rights as well as other rights are violated by public authorities. Hence the question. The version of the legislative provisions regarding the application of the non-constitutional law of Ukraine, and we are not speaking here about other acts of secondary legislation or internal regulations of the bodies of authority. Sorry? Okay. Yeah, I think that it would be advisable to consider this issue both within the judiciary and in the lawmakers' authority of Ukraine. And the opinion of our international colleagues would be most useful. The constitutional complaint as an effective tool to protect human rights operates very effectively in a number of European countries. There are some less positive examples, of course. The states that are close to ours in terms of the history and culture, we can look at the example of Poland, where the constitutional complaint is still an issue, and the experience of the Czech Republic, where it functions perfectly based on the German model of the constitutional complaint, where the Senate and the Constitutional Court that has three judges who consider thousands of such complaints once all other remedies are exhausted. And only after that can the application go to the European Court. And that would be a minute fracture of such cases, such complaints. And those that end up in the European Court pose or raise very important legal matters, legal problems. These are not massive, repetitive, systemic complaints or application, and that may reduce the caseload in the European Court. According to the latest figures, today, the ECTHR has pending 10,000 cases versus Ukraine, of which 2/3 refer to the armed aggression of the Russian Federation against Ukraine. Others, that 1/3 of remaining cases, by say 90% or even more, are the repetitive applications, and they have already been considered by the European Court vis-a-vis Ukraine. And these are the applications that should not land on the dockets of the European Court. So it's not the problem for the ECTHR, it can cope, but it is a problem for Ukraine, the problem of the true implementation of the constitutional provisions of Ukraine. The constitution that we're celebrating today is also a living document, excuse my banality, and genetically it is closely linked to the European Convention on the Human Rights. Section 2 of the Constitution of Ukraine practically covers all of the matters or rights protected also by the European Convention. And we have a wonderful opportunity to support the dialogue between the Constitutional Court of Ukraine and the European Court that can lead them to greater efficiency and effectiveness. Then the Constitutional Court of Ukraine will have a much more prominent role in the state than today. Here we need goodwill on the part of the lawmakers and institutional capacity of the Constitutional Court. The ECTHR case law contains several judgments where the Constitutional Court of Ukraine is referred to. In one case, in the very positive context, when in the case Nichiporenko versus Ukraine, whereby the Constitutional Court addressed the issue of a payment to the former police officer of his monetary allowance. And in essence, that was upheld by the European Court of Human Rights, even though there were 3 applicants with analogous constitutional complaints, but judgments were different, even though they were almost identical in the language. And there's also a case Kuznetsov and others versus Ukraine. It's about compensations for the individuals that were subject to remote or e-judgment or justice. And it was about the duration of the adjudication, because the national court did not consider such complaints, waiting for the Constitutional Court to rule on the constitutionality of the law on the purification of power. So thus the judgment was taken, but with a 5 years delay. So there is room for improvement, of course, and I would like to ensure you that we in the European Court believe that the Constitutional Court is our key partner, and I hope that the constitutional complaint as a notion and the practical tool will become accessible, will enable the applicants to raise matters and will be considered by merit, and the results of such resolution will be realistic. They should address the problems and they should remedy the violation.
Hopefully soon we'll all be able to say that the criteria are fulfilled. Thank you very much for your attention, and I will be grateful for any questions. If there is a chance for questions, it's great. If not, I will continue to listen to further presentations. Thank you. Thank you, Mr. Mykola. Indeed, your very interesting presentation, food for thought, and I support you. I have hope that in Kiev, Strasbourg, or other great cities, we will continue our further scientific discussion. Under the session, we'll move to brief presentations. A reminder to the participants of our conference. Our time limit is 10 minutes. I pass the floor to Yuri Popashvili, a great friend of Ukraine. He has many statuses and regalia. As the former chairman of the Constitutional Court of Georgia, the expert of the Venice Commission. Today, we are pleased to note that Mr. Georgi is the special advisor of the Constitutional Court of Ukraine, and in many proceedings, he provided his expert opinion on matters examined by the Constitutional Court of Ukraine. Mr. Georgi, the floor is yours. The topic of the presentation is the role of the Constitutional Court in approval of the concept of the European concept of human rights and the practice of Georgia. Please. Thank you, Mr. Oleg. Can you hear me? Yes, we're listening to you. And dear colleagues, dear friends, thank you very much to the Constitutional Court of Ukraine and co-organizers for inviting me to take the part in the international conference on Constitution of Ukraine and Triads of European values. The perspective in the light of European integration dedicated to the Constitution of Ukraine Day. The Constitution adopted on the 28th of June 1996 approves the path of independent development of Ukrainian state and became the symbol of consolidation of Ukrainian people. So, using this opportunity, I'd like to express the warmest greetings and the heartiest words of support for Ukrainian people. We admire your strength and courage in fighting Russian military aggression. All world is admiring. I sincerely believe in the victory of Ukraine over aggressor and liberation from occupiers and restoration of international peace and global order. Glory to the defenders of Ukraine, glory to Ukraine. Glory to heroes.
Now I will move to the topic, but very briefly. I understand we are a bit behind the schedule. So I will speak about the role of the Constitutional Court, that my predecessor, Honorable Judge Gratowski, already mentioned the role of the Constitutional Courts in this context, but I will speak basically very briefly about Georgian example, and I hope that next time I will be with you in present, in life, and I understand the security reasons I could not come to this time, but next time maybe I will take my responsibility to join you in life in times of difficulties, because when the peace and victory will be in Ukraine, of course everybody will be there, but it's important that to be with you in during this time of difficulties. So, international treaties and agreements of Georgia, as well as in many other countries like Ukraine, are part of the domestic legal domain and affect various legal relationships. Georgian Constitution, recent amendments of 2017 emphasize that the Georgian Constitution emphasized that ratified international treaties must comply with the Constitution, and the Constitutional Court has an important role because the court exercises both a priori and that's the only case when Georgian Constitutional Court has a priori right to review the constitutionality, as well as a posteriori constitutional review of international agreements. And then it's important to mention that in the recently in 2017-18, after the amendments of the Constitution, the special provision was incorporated that integration into European and Euro-Atlantic structures to specify as a goal of the Constitution. Namely, the provision reads as follows. It's something similar to the Ukrainian amendments made a bit 1 year or 2 years later. The constitutional bodies shall take all measures within the scope of their competencies to ensure the full integration of Georgia into the European Union and the North Atlantic Treaty organizations. So after the enactment of this amendment, this is the constitutional principles already. The association agreement between Georgia and European Union concluded 2014 requires Georgia to adopt numerous legislative amendments and ratify relevant international treaties. Regulatory spheres of the acts ratified by Georgia can encompass a wide range of areas of life, including competition and freedom of enterprise, right to private life, protection of consumers, personal data, etc., etc. The Constitution is not unlikely to develop something like disparate approach towards various matters, establish a bit distinctive human rights standards, or provide for different grounds. But respect for national identity and constitutions of the European Union member states is explicitly provided in Article 4 of the Treaty of the European Union. In order for the normative base created by the ratified international acts to remain close to basic principles of the Constitution and preclude contradiction between them, the Constitutional Court holds a key role. Court, by reviewing the constitutionality of international agreements, on the one hand, exercises the constitutional control on effective implementation of the integration of the EU law, and on the other, ensures that international treaties and their implementation measures are in compliance with the Constitution. Implementation of EU law is not solely limited to ratifying an incorporation of acts adopted in the EU by the legislative body. It's a far more extensive matter and encompasses entirely analysis and practical application of the international principles and standards recognized by EU by the judicial branch of the Georgian government. Full-fledged legal harmonization of Georgia and the EU entails implementation of the common principles and values into the legal domain. Participation of the Constitutional Court in this process is important, as while deciding on specific cases, the court studies and draws on inter alia the best practices, human rights protection standards, legal principles and values of the European Union. Adoption of the European Union law and its principles into the case law of the court simplifies the harmonization and integration of the legal domain, and this way promotes the achievement of the goal of Georgia's full-fledged legal approximation with the European Union. The mentioned constitutional provision about the constitutional principle of integration in the European Union and NATO refers to every constitutional body, and hence the obligation to ensure the integration is bestowed only upon the legislative executive branches of government, but in principle on the judicial bodies likewise, including the Constitutional Court. In this context, it's interesting what additional obligations are brought by the mentioned provision to the court as a constitutional body tasked with promoting the integration. Obviously, interpretation of the content of the constitutional provision will be conducted by the court itself sometimes, but has not yet had chance to do so. At this stage, it can be assumed that this article further encourages the court to draw on the European Union law, case law, and standards of the European Court of Justice in the process of constitutional adjudication on the complaints referrals. Applications of the standards and principles of European Union law in the process of constitutional adjudication will undoubtedly be positively reflected on the process of legal integration of the country in European standards. Let's just briefly to summarize some of the specific cases. One of the latest judgments where the court essentially implemented the standards envisaged by the association agreement involved the constitutionality of the provision of the law on Georgian tobacco control, which prohibited the sale of tobacco products within a 50-meter radius from the educational and educational care institutions and in the territories adjacent to them. Through the association agreement, Georgia undertook in the area of public health the obligation to enhance prevention and control of addiction to tobacco, and also the obligation towards effective implementation of the Framework Convention on Tobacco Control, and the obligation to consider the Council recommendations on prevention of smoking and on initiatives to improve tobacco. So based on the specific facts, the court adopted a wide margin of appreciation for states set by the association agreement and the convention in the area of public health, protection and increased interest of protecting minors, and ruled that public interest of preventing tobacco popularization and advertisement prevailed over private interest to sell tobacco products and entrepreneurship activities. Moreover, the Constitutional Court in another case of 2016, as an additional complementary instrument to the primary reasoning of the judgment, used the specific directive of European Union on the freezing and confiscation of instrumentalities and proceeds of crime in the European Union. The Constitutional Court assessed the constitutionality of the regulation, which provided for the possibility of freezing property of the accused, of the person materially responsible for the actions of the accused, and of the person related to the accused. If there is information to suggest that property will be concealed or destroyed and or property has been obtained in a criminal way, the complainant positioned that the disputed regulation violated the right to property, as it enabled the possibility of property seizure even if there was no connection between the property and the criminal actions of the accused. The court, in the reasoning part of the judgment, pointed to, among other arguments, to the European Union directive, which obliges member states to adopt minimum legislative safeguards for the detection and tracing of property obtained in a criminal way to be frozen and confiscated. By indicating to the EU standards, the Constitutional Court determined the case that the restriction prescribed by the disputed measure was proportionate and has constitutional. In another case, one more case, just briefly, the complainant argued that the state had given preference to the Georgian Post as a government-established enterprise in the postal and courier service market over the competitors by excluding over commercial agents from the relevant market. Therefore, the disputed law has created a legal prerequisite for the Georgian Post to establish a monopoly on the postal and courier service market, which per complainant's submission contradicted the freedom of enterprise and competition guaranteed by the Constitution. The court established that the disputed regulation interfered with the freedom of enterprise, and in the reasoning, the court drew heavily on the EU standards and case law of the European Court of Justice, and the specific law on competition law, in particular, Article 100 of the Association Agreement between Georgia and European Union, which lays down the criteria which have to be met in order for universal service obligation not to be regarded as anti-competitive per se. So in conclusion, so the court already in its jurisdiction has developed some argumentation that is intended to align national constitutional standards with European Union acquis communautaire. This interpretive strategy surely helps generally Georgian efforts to integrate with the European standards. Щиро дякую.
Дякую, пане Георгій.
Thank you, Mr. Georgi, and we're really convinced that the Georgian and Ukrainian lands will be liberated from occupiers, and Georgia and Ukraine will continue our discussion. Dear colleagues, the minimal changes in our agenda due to technical and other problems. So now the floor is given to Olena Frolova, representative of the ombudsperson in their fair trial and representative in the Constitutional Court, where the topic of presentation, parliamentary control over adherence to constitutional rights and freedoms of human being, modern problems. Olena, the floor is yours, 10 minutes. Can you hear us?
Намагайтесь включити мікрофон, зараз адміністратори дають доступ. Дякую.
Good afternoon, dear Mr. Chairman, dear participants. Thank you for the information, for introductions. I would like to thank Serhiy Petrovich for invitation to the conference and to express my respect to the activity of judges of the Constitutional Court of Ukraine and to greet you on the occasion of 27th anniversary of approval of the Constitution of Ukraine. Regarding this decisive day and the topic of the conference, I'd like to know the following. The association agreement between the Ukraine and the EU and Euratom and their member states on the other side, and the status of the candidates for Ukraine. It opens wide opportunities for Ukraine, but also creates additional obligations to fulfill requirements for adaptation of Ukrainian law to the EU acquis and to perform political and socioeconomic, legal and institutional reform to build an established democracy and market economy. In association agreements, we recognize that we share the European values, in particular democracy, respect for human rights, the basic freedoms, and rule of law. These are our joint values. Today, the activity of our institution emphasizes the mentioned European values. Ukrainian law partially complies with European law. It implements the recommendations of the ministers of the Council of Europe. Also, our national law and current activity of the institutions of ombudsperson are in line with the UN resolution on protection of human rights. When we talk about parliamentary control over constitutional jurisdiction, I'd like to say the following. The Constitution of Ukraine and the laws of Ukraine and the Constitutional Court of Ukraine as the ombudsperson of the Parliament of Ukraine implement individual access to constitutional justice. At the moment, the citizens have the right to apply not only to the Constitutional Court directly with constitutional complaints, but also indirectly through the ombudsperson, raise the issue on necessity of constitutional filing to declare that some act or its provisions are unconstitutional or unofficial interpretation of the Constitution. The potential of ombudsperson as a direct form of access of citizens to the Constitutional Court of Ukraine is used not very efficiently. Mr. Mykola Gnatevsky mentioned that a great number of cases sent to ECHR, they don't have to go there and they have to be reviewed in national courts. And then they have to be implemented. The conclusions we can draw on the review of complaints by the ombudsperson. Sometimes the complainants don't have the satisfaction from the decisions of public agencies. Often those decisions are legal and fair. Also, there are complaints to protect rights that were not violated by the public agencies because applicants directly applied to the ombudsperson bypassing all other entities. Most often, citizens or NGOs do not apply to any public agencies which violate human rights, and so they have the competency to make the claims. Over the period of 2022 and the first half year of 2023, the Secretariat of Ombudsperson reviews 122 complaints of the citizens. And all the year 2022, this number was 65 applications. Over 2023, over the first half year. As of today, we already have 57 applications. The amount of applications is growing, but none of these applications became the grounds for constitutional filing.
But also because the detailed scrutiny of the Secretariat's experts of such complaints testify to the wrong interpretation of the legal act by the applicants. And we understand the complex nature of these matters, so we provide very detailed reasoning while denying the opening of the cases. When it comes to the national constitution, the ombudsman used other acts. He would write to local authorities, the national executive authorities, so that their public officials take measures to reinstate the violated rights of the individuals. The ombudsman does not have the right of legislative initiative, but he can propose certain amendments to the individual MPs, and now we use this right to improve the complex and sophisticated or else controversial legal norms. I can say that the Ombudsman Institute is a filter when it comes to applying to the Constitutional Court. I will give you a number of examples when it comes to the application to the Constitutional Court. Application to the Ombudsman should be well justified and pertain to personal experience of the applicant. And we have several such applications. One pertains to the constitutionality of the resolution of the Supreme Rada of Ukraine, Verkhovna Rada of Ukraine, of certain pieces of legislation. So it does not directly affect the rights of the applicant, and the consideration of this resolution might bring about the legal collapse on the country. So we had to explain this situation to the applicant, saying that the entire legal framework provides for the consistency and the principles of the temporality of the action of the acts of law. In addition, we need to remind the applicants that the laws on the the application of law in the temporarily occupied territories has been considered by the courts before when it came to the constitutionality. Particularly when it comes to the acts adopted during the Soviet times. The ombudsman should not act in lieu of the judicial institutions like general courts or else constitutional court. The ombudsman would not consider applications that should be addressed to courts. They would stop consideration and they would respond to the applicant accordingly. We need a whole list of applications whereby the applicants are not satisfied with the fully lawful and legitimate court decisions. Then a person who receives free legal aid demands that their cases should go to the upper instance court, even though they have got all the remedies provided by the local court. So we in the Ombudsman Secretariat do not act in lieu of the executive or law enforcement authorities either. And we have several applications with complaints against the acts of the national police or the prosecutor. We had several applications from the inmates that complain against the administration of the courts, even though of the prisons, even though they should have been addressed to the bodies of prosecutorial authorities. And we have to explain that to the applicants as well. Citizens sometimes ask us to address their issues related to utilities, utility bills, etc., because they fail to trust the executive authorities, local governments, or else they do not know what the mandate and powers of the Ombudsman and Ombudsman Secretariat are. So instead of preventing the violation of human rights and fundamental freedoms, the Secretariat of the Ombudsman needs to provide explanations and work instead of the executive authorities or local government. Thus, we need to educate the civil society and citizens about the separation of powers and about the remit, the powers of the Parliamentary Commissioner for Human Rights. The institution of ombudsman is by and large in line with the European acquis, and it would be even better consistent with that if all of the branches of power work in unison. And we still need better regulation of the process of application to the Ombudsman Secretariat. I hope that our bilateral cooperation with the Constitutional Court will develop in a dynamic way and will be even deeper. Thank you very much for your attention. Thank you, Olena. It was useful for us to hear about the status and activities of the Secretariat of the Ombudsman. Thank you very much. Our next presenter would be Vitaly Kovalchuk, head of the Department of Constitutional and International Law in the Educational and Research Institute of Law, Psychology and Innovative Education of the Polytechnic National University. He will be speaking about constitutionalism in the times of war, struggle for values, rights, and identity. Do we have Mr. Kovalchuk with us? I think we do. Can you hear us, Mr. Kovalchuk? We can see you on the screen, your avatar, but we are not sure you are there behind the avatar. If this is not the case, and I would encourage our technical assistant to establish a connection with Mr. Kovalchuk. We've got Mr. Serhiy with us. He's Vice Rector for Science and Pedagogical Work of International Cooperation of Ivan Franko National University, Doctor of Law and Professor. He will be speaking about narrowing the content and scope of human rights in the adoption of Regulatory Act as a ground for their non-constitutionality, problems of reasoning in the process of constitutional oversight. Esteemed Chair, Mr. HOLOVATY, esteemed colleagues, I would like to thank you for inviting me to speak, and I hope that my colleague Vitaly from Lviv will join us very soon, so that the large proportion of the expert board of the Constitutional Court will have a say in this conference. So warmest greetings on the Constitution Day. Sorry, please be muted, those who are not speaking. Today, in the times of war, it is fairly problematic to celebrate any holidays, but it is essential to underscore the value and the necessity of the Constitution, and we should celebrate even minute victories despite all of the atrocities and tragedies of the war. Today, I'm sure that our citizens are better aware of the Constitution norms thanks to the reach out and information awareness work of the Constitutional Court. This conference dedicated to very specific issues of democracy, human rights, and rule of law will find understanding in the society at large. We are speaking about European integration and other topical issues that have to be addressed both today and in post-war Ukraine. One of such issues would be the human rights in the context of Article 22 and 24 of the Constitution of Ukraine. This topic, no doubt, will remain relevant, particularly at the backdrop of today's events. When it comes to the narrowing or limitation of certain rights or the scope of certain rights, the abrogation or derogation from certain rights. And it is important for us to thoroughly scrutinize every every eventuality under which this limitation can be possible. So we understand that while laws are amended, the content and scope of human rights cannot be narrowed or limited. The Constitutional Court gave several definitions of the scope and content of human rights and fundamental freedoms in a number of its resolutions, and it spoke about the content of human rights as the measures that ensure the rights necessary for human development and existence, and the quantitative indicators of the opportunities of a person that are not homogeneous and common. And the rule is common, according to which the content and of the human rights cannot be violated. The Constitutional Court, in another decision, defined the narrowing on the content of human rights and freedoms as the reduction of the signs of the rights of the person, that is the qualitative characteristics of the law, and the narrowing of the scope as in reduction of the round of subjects enjoying this right or freedom. That is quantitative indicators or characteristics. As I said before, the content of paragraph 2, Article 22 of the Constitution of Ukraine should be seen in its conjunction with Article 64, whereby constitutional rights and freedoms cannot be limited or restricted, and the cases that are provided by the Constitution, only temporary limitations can be established with sunrise provisions. And oftentimes in the literature, the notion of the narrowing of the content and scope of human rights, or the limitation of those rights, not when legal acts are adopted. Just oftentimes we see the confusion here. And oftentimes the conclusions are that any regulatory limitation of human rights is tantamount to the narrowing of their content and scope, hence the violation of the principles of equality, etc. So this position, to my mind, is not very convincing, and we should delineate these things. Of course, the narrowing limitation of human rights, the narrowing of the content is a limitation, but not every limitation deals with the narrowing. Article 22 and 64 otherwise would not be consistent or cannot be compatible. So the narrowing of the constitutional and the limitation of the constitutional rights are different notions. And whereas the first one, when the new laws are adopted or existing laws are amended, is not possible. In the latter case, as we quoted from Article 64, can be allowed. The narrowing of the content or the scope of the human rights and freedoms are not allowed under Article 22, but it will take place under two circumstances. When we speak about the constitutional rights and freedoms, those which are reflected in the Constitution directly, that are inherently constitutional, or when the essence of the constitutional rights is violated, and the definition of this essential content should be undertaken by the Constitutional Court, so that we could conclude whether Article 22 has been violated and whether there are grounds to believe that a certain regulatory act is non-constitutional. The brightest example of that would be again, to my mind, the decision of the Constitutional Court, the memorable one, vis-a-vis the law on the prevention of the financial disaster in Ukraine, whereby the law abrogated the cancellation of canceled the maternity allowance when the second child is born. And that meant the violation of Article 22, both in the content and the scope of the right was narrowed by the Constitutional Court, quite expectedly, methodologically correctly, ruled that this law is in line with the Constitution, since the essential content of the right was not violated, and it took into account the circumstance that when it considered the constitutionality of the law, it had to establish the root cause of the problem. When the right, whether it was provided for the satisfaction of electoral purposes or by a certain political force, or whether it is constitutional in its nature, whether it is inalienable as a human right, or whether it was a result of the malefied political process. So we have to establish causative consecutive relations and the objective impact of the act on the content and scope of the constitutional right of the person, of the individual. So Article 22 should be invoked only in the cases when the law itself, the act itself, becomes the reason for the negative impact on the statute of observation of this certain right. And if the law were cancelled, then the development of the events would be totally negative. I'm sure we will receive lots of such complaints in the future dealing with the limitation or narrowing of rights when it comes to the martial law, that the political powers that we had to introduce to ensure security. And in the post-war time, the issues of financial support to individuals will also arise.
The Constitutional Court of Ukraine, with current dynamics of development, has many practical and organizational developments and significant professional capacity to resolve cases professionally. We wish Constitutional Court success in doing this and victory to all of us. Thank you. Thank you, Mr. Serhiy. A very interesting and useful presentation. Colleagues started to respond immediately to your opinions, and discussions was ignited. Unfortunately, our agenda doesn't allow us to discuss this, but it shows the prospect of your topic, and we really need victory to work freely and to discuss interesting topics like this. Going back to our agenda, we have our next speaker, Vasyl Kovalchuk, the participant of the conference, Chief of Department of Constitutional and International Law of the National University of Lviv Polytechnic. And the topic of presentation is constitutionality and the war, fighting for values, rights, and identity. Mr. Vasyl, the floor is yours. Good afternoon, dear participants of international conference. Thank you very much for invitation and opportunity to take part in this important event. Greetings on the occasion of the Day of Constitution. The topic of my presentation relates to the matter of values and rights and identity. It has more democratic nature. Maybe it should be in part one of the conference, but I will try to concisely present this now. Constitutionality is the key of the modern European civilization, is the political legal phenomenon which is related to limitation of state power in the interest of civil society and protection of rights and freedoms of human being under the Constitution. It is the epitome which this hierarchy of values. The basis is dignity and freedom. Constitutionality includes the sets of expectations related to the behavior of the government. The modern Ukrainian constitutionalism under the war, the martial law since 24th of February 2022 gets some identification, gets some modification. What is the modification? It's the need to improve the ideological components of the concept of constitutionalism as constitutional legal consciousness towards the national idea, national identity, and national dignity of Ukrainians. The modern problem of Ukrainian constitutionalism is formed on the principles based on general human and European values. Even under martial law, they will not be modified. The second is this changes in the functional mechanism of constitutionalism, which are caused by the need to ensure by the public agencies that to strike the balance between the security and freedom of citizens, supporting the civic rights that cannot be limited during the war. Third, forming identity in the new post-war constitution that has to become the reflection not only of Ukrainian people, but it's the rise for political future in the United Europe. Under the martial law, the problem of values is felt especially acutely. The war allows to test the reality of chosen values and readiness of citizens to the state government to defend and to adhere to them. In these extreme circumstances, a special role is played by the moral and spiritual values, patriotism, readiness for sacrifice, heroism, the issue of state sovereignty and values of the state, and so on. They became the priorities for Ukrainians because ideology of Russianism denies the existence of Ukrainian nation, as it was properly identified by the Parliament of Ukraine on the 2nd of May 2023. The ideology of Russianism is totalitarian and it is human-hating. The war in Ukraine has bright existential nature because it touches on the choice of the future of every Ukrainian and Ukrainian political nation in general. In this war, Ukrainians protect not only their rights for existence as a separate ethnos, but also they protect their general human values, in particular, which are written in the Constitution, freedom and democracy. European choice of Ukrainian people as a result of Orange Revolution and Revolution of Dignity was reflected in the conditions of war. As sociological polls show, in particular the survey of LEMAK Center conducted in September and October 2022, Ukrainians remain adherent to the ideas of freedom and democracy, and they're less adherent to totalitarianism. In 2010 to 2021, the support for democracy among Ukrainians was 48 to 56%. Authoritarianism was 18 to 24%. In the conditions of full-scale war, after 2022, the number of supporters of democracy idea grew 68%, and supporters of authoritarianism reduced to 11%. When there is a need to choose what is more important, freedom or equality, 71% of citizens say that freedom is more important. However, when the choice is between freedom and security, Ukrainians often choose security. 56% are for security and 46% are for freedom. Security and the war for citizens of Ukraine often is associated with strong unlimited power. Based on the results of the above-mentioned sociological survey, the level of support of citizens of the political system, which envisages strong leader, independent from the parliament and the election, is 61%. In addition, part of respondents believe that it is good or very good to have the political system in which the government belongs to military or military regime. This attempts to combine democracy and elements of authoritarianism on the war is clear, but they have some negative symptoms. They can create conditions for growth of support in the post for Ukraine of populism parties and leaders who would try to use patriotism to usurp power and to create the conditions for involution of institutionality and human rights. The potential for the scenario in 1930s was mentioned by a German constitutionalist Guy Richstein in his famous work, War, Democracy and Fundamental Rights. Wittgenstein explained the concept of a military democracy which can protect itself. He mentions that a legal state in extraordinary conditions can limit the rights of humans. Obviously, this concept creates significant risk. The methods of war democracy, militant democracy, can be applied by the populist parties of authoritarian nature. In particular, Wittgenstein saw the countering of these threats by ensuring that human rights are really institutionalized. They are protected by strong and controlled institutions which function on the basis of division of powers. Under the war, actual application of the division of powers is complicated because there is objective change of functioning of the mechanism of constitutionalism, which are caused by the needs for more efficient ensuring of state sovereignty and national security. According to the Constitution of Ukraine, these functions fall under the President of Ukraine. According to Article 102 of the Constitution, the President is the guarantor of the state sovereignty and territorial integrity, and also he implements the strategic course of the state for gaining the full-fledged membership in NATO. Regardless of benefits of constitutionalism and making decisions in extraordinary conditions, it carries some threats for constitutionality. Attempts of the president to take over characteristic powers which are not envisaged by the Constitution, intervention into judiciary, law enforcement, prevention in the work of opposition media, establishes threats to individual human rights like right of freedom of speech, the right for fair trial, and unbiased justice. During the martial law, the public agencies often make decisions applying the principles of political feasibility. Sometimes it overrules the legality. In terms of legitimate objective, victory over enemy, this can be considered justified, but due to the concerns that this decision of the government has to be justified and proved in the court. In the other case, we will put in doubt the principle of a rule of law. The typical situation can be observed when the decision of the Security and Defense Council was to suspend the activity of 11 political parties. If the anti-state nature of these parties is obvious, and the proportionality principle is followed in achieving the goal, then the level of arguments that was applied in the decision is beyond criticism. In this specific case, not everything is positive with legality, as at that time, the law of Ukraine did not envisage the procedure of suspension of activity of political parties, only prohibition of activity of the parties based on the court ruling. Under the conditions of war, it is important to have institutional capacity of the state to ensure rights and freedoms. The legitimacy of applying extraordinary measures lies in two perspectives. First, these measures have to be urgent and have to remove threats to the civil rights. Second, the accountability and control over the public agencies have to include judiciary and targeted control. It's important to have institutional mechanism based on the above mentioned. I'd like to make some conclusion on values and rights and identity, and they're falling under the conditions of war. There's objective change of function of mechanism of constitutional democracy, which are caused by the necessity for more efficient ensuring of state sovereignty and national security of Ukraine. This requires from the public agencies maximal mobilization and interaction for achieving the legitimate purpose, the victory over enemy, and protection. Under these conditions, it is justified to have partial limitation of human rights, in particular political rights. However, during the war, you cannot violate the fundamental rights, which are concentrated around two basic values, the freedom and the dignity of humans. Forming Ukrainian political nation in the post-war periods should be done based on the new constitution. It should become the real social contract of the Ukrainian people, the citizens of all nationalities, around appropriate values. The basis of this contract should be three decisive points, in particular, the freedom and dignity of individual, identity of the nation, supremacy of constitution and international law. They have to be reflected in preamble of the constitution, which is the basis for constitutional identity. Thank you. Thank you, Mr. Vitaly. And at the end of this session, human rights, the floor is given to Vladimir Stimenko, the member of Presidium of the Academy of Sciences, the director of the Institute of Legal Research, named after Mammoth, the Doctor of Legal Sciences, professor, correspondence member of the National Academy of Legal Sciences. The topic of presentation is socio-economic rights of humans, European trends, and challenges of the martial law. Mr. Vladimir, the floor is yours up to 10 minutes. This feeds the agenda. Thank you, dear Oleg Petrovich and Serhiy Petrovich, for this chance to express my position. Can you hear me? Yes. Now, I would like to share my presentation. Can you see the presentation? Not yet. Now we can see it. I would like to thank our armed forces for giving us the opportunity to hold the conference, for the work of our air defense, which also gives us the opportunity to work confidently. I already have heard some positions that I wanted to present. I fully share the opinion of Yulia Krishenko, who mentioned that one of the factors which caused the war aggression in 2014 and the full-scale aggression in 2022 is our civilizational choice of the Ukrainian society, which is directed at the European integration in European identity. Our main difference to the previous Soviet time is that we had the worldview transformation in the choice of the way of life, where the human rights, the human dignity and human freedom are the supreme value of the society. Our society, being part of the civilized humanity, perceives the approaches to forming of socio-economic rights of human, which were reflected in the General Declaration of Human Rights approved by the UN General Assembly back on December 10, 1948. The further specification of them happens in international compacts on economic and social and cultural rights as of 16 of December 1966, adopted by this distinguished international institution. The fulfillment of powers in this context by our country. Annually, we prepare the reports, the national presentation, national report, and the Ministry of Social Policy provide the recent report in 2019. Ukraine reinforces and implements the global values and human rights in the Constitution and legislation of Ukraine. Constitutional Court of Ukrainians' activity emphasizes the attention on the protection of these economic and social rights. The property right for the results of intellectual and creative activity, the entrepreneurship activity rights, so the right for social protection, the right for healthcare, and the right for safe environments, for life and health, the rights of free access to information on the condition of our environments, the right for education. Also, the right for compensation of damages caused by the state, the right to know your rights and duties. I need to say that the number of applications to the Constitutional Court on social and economic rights is growing. This trend is characteristic also for the European Court on Human Rights. As of 31st of December 2021, the distinguished Mykola Granovsky mentioned to this as of 31st of December 2021 in the Register of European Court for Human Rights. The total registered number was 70,150 applications. 75% of them are from 5 countries. Against Ukraine, there were 11,372 complaints filed. Only 2 states have more complaints against them. It is Russian Federation, 17,013 complaints, and Turkey, 15,251 complaints. To compare, as of 2019, these complaints against our country were only 7,200. Most complaints concern social and economic rights. Also, there are some related to military aggression, but they also are related to the damages caused to our entities and citizens, and economic entities, and the problems with their implementation, as complainants believe, and they were not able to implement this in our judiciary system. It is mentioned that this shows the increase of sense of injustice in Ukrainian society. This is added by the situation that the level of execution of the rulings of ECTHR is one of the worst in Europe and Ukraine. Over the past 10 years, the Ukrainian government did not execute 67% of judgments of the ECTHR. The leader in this list is Hungary and Russian Federation. The human rights in legal literature traditionally are treated as some opportunities which are necessary for existence and development in the specific historic conditions.
These rights are defined by the level of the human development, social, economic, and environmental. And it is essential that the implementation, the enjoyment of social and economic rights is impossible or hampered when there are no material ground for that. So the impact on the level of the implementation of the rights is dependent on the situation in the national economy and in the global economy, which we witnessed during the pandemic. The armed aggression of the Russian Federation against Ukraine changed the situation with the availability of resources in the country. It had an adverse impact on the ability of the economy to collect VAT and other taxes. But according to the Minister of Finance, in 2023, the expenditures of the national budget went mostly to defense and security, 53%, social protection and social welfare, 15%, public order, security and judiciary, 12%, and public health, 5%. Yeah, these expenditures have declined as compared to the year 2022, with defense increased by 4 times, with social protection increased by 25%, with a public order in 1.6 times, and they decreased when it comes to public health or education by 2.5%. Notably, the weight of the tax revenues was 57.7% as compared to 2022. So all taxes and charges coming to the budget of the country regulated within its territory are used to cover the defense needs, which is quite natural in the times of the war, because if we fall to aggression, there will be no speaking about human rights or fundamental freedoms. And the implementation of those rights does depend on the budget revenues or on the money provided by the partners of Ukraine. The situation in the economy does not testify to the resilience of the state and its capacity to ensure social and economic rights of individuals without the support of our international partners. And we can look in this context at the situation with the pension fund of Ukraine. As of the 1st of March 2023, there were 389,000 of courts that took their effect, according to which 42.9 billion hryvnia should be paid to the retired people, whereas the allocations from the budget are only 360 million hryvnias, which is only 1% of the need to cover the arrears. So the Constitutional Court took several decisions that will show the need to pay large amounts as part of the social allowance. And the Ministry of Social Policy will have to pay annually ensuing the decisions of the Constitutional Court, huge amounts, like 25 billion hryvnias, 1.7 billion hryvnias, 40.4 billion hryvnias, 10 billion hryvnias, according to different decisions of the Constitutional Court, totaling more than 100 billion hryvnias. Now, looking ahead, we can anticipate that the economy would not be developing so as to allow payments out of the pension fund of Ukraine. And the availability of the money depends on the entrepreneurial activity within Ukraine, and the guarantees of social and economic rights of individuals will be predetermined by the economic capacity of Ukraine, the post-war recovery and economic growth in the post-war period. Based on the aforementioned, we can make the following conclusions. The guarantees of social and economic rights are directly determined by the ability of the state to provide for these rights. Challenges of the wartime reduce the capacity of the state to make sure that the individuals enjoy their social and economic rights. And here I would refer to the intervention by Mr. Riznik. The disbalances between the commitment of the state in the social sphere and its capacity to provide for those rights requires further research and modeling. And perhaps in the future, we will need to revise the social agreement that Professor Kovalchuk mentioned before. Thank you very much for your attention. I hope that I kept within the time limits allocated to me. Thank you. Thank you, Volodymyr. You're almost there. Thanks for respecting our time limits. Now we will break for 5 minutes, okay? And at 3 sharp, we will continue our work, and we will have the section dedicated to the rule of law. Thank you.
До нашої третьої сесії. Це питання.
Dear colleagues, now we start our third session, and we will be speaking about the third component of the European values triad, which means the rule of law. And the moderator would be esteemed Judge of the Constitutional Court, Ms. Serhiy. Dear colleagues, it is my great pleasure to congratulate you on the Constitution Day. This day embodies our identity, our values, our aspirations on the path to the freedom, sovereignty and human rights. It is sad that we are celebrating this day under these sad circumstances, but we are fighting for our values and our identity. And we, in our respective capacities, should do everything to bring our victory closer. So it is important for us to demonstrate unity in understanding these values. It is my great pleasure to moderate section 3 of our conference. And as Mr. HOLOVATY has said, it is dedicated to the rule of law. By way of introduction, I would like to emphasize the legal positions of the Constitutional Court vis-à-vis the rule of law over the last few years. First of all, I cannot but mention the constitutional reform and that the rule of law as a principle is well recognized in Ukraine. So Constitutional Court of Ukraine, one of its first decisions dedicated to the rule of law in the case on the mild punishment to be appointed by the court. It is about the right which is not limited by legislation, but also includes other social regulators. These elements of the law should be in line with the ideology of fairness and justice. The further development of this notion shows that we are moving from the integral approach to the element by element approach. And in following decisions, the Constitutional Court also looked at the elements of the rule of law. In the case on the permanent use of land plots, the elements of the rule of law were described as clarity, equality, and the insurance of the equal application of law. Thus, it prevents the arbitrariness. In one of other decisions of 2019, on early termination of the powers of parliament and appointing elections, the Constitutional Court interpreted the rule of law as a three-component formula: the use of the power and protection of the individual against the arbitrariness of the state powers, and normative ideal to be pursued by every system of war, and the third, the integral and universal nature of the rule of law. In the decision on the pension cases, the following elements of the rule of law were identified as the national sovereignty, democracy, legal certainty, fair trial, legality, etc. This structure allows us to implement the standards of the rule of law formulated by the Venice Commission. I would like to specifically emphasize the decision of the Second Synod in the constitutional complaint of Levchenko, and the rapporteur was Mr. HOLOVATY, whereby the rule of law as an integral element of the system of values underlying a modern European order belongs to the triad of values alongside true democracy and human rights.
була запропонована українська
In this judgment, the Ukrainian formula of rule of law was proposed. Today, these two terms are used by the constitutional terms of Ukraine as synonyms. And this formula is in Article 8, from which I started my moderation. It says that rule of law is recognized, that is the first component, and the rule of law is effective. First is the rule of law is recognized. It is the imperative of recognition of the rule of law. It is the recognition of the state of Ukraine at the international level by joining the Statute of Council of Europe and ratification of Convention on Protection of Human Rights and Fundamental Freedoms, and also national by regulating the principle of rule of law and the Constitution, and also by regulating in regular laws as the guidance for activity of public agencies. And second component of Ukrainian formula of rule of law is effectiveness, which ensures its practical importance. It is the set of national institutions, mechanisms, and procedures which are important for the individual to be able to possess human dignity and to protect themselves from arbitrary actions of the state. And of course, I have to emphasize this linkage of rule of law, which is brightly mentioned in the first section. And I have to remember the decision of 2018 on social rights, where also Constitutional Court of Ukraine mentioned ontological status of human dignity as the rights, according to Article 28 of the Constitution, and the value which fills human being with sense is foundation of all other constitutional rights, the measurement for identifying their essence, the criteria of admissibility, and possibility of limitation of these rights. And this understanding is too important in the extreme conditions, even now, onto the conditions of military threats to the Ukrainian state. This is a brief overview of the developments of legal positions of the Constitutional Court of Ukraine on the principle of rule of law. I allowed myself to express this, and now we move to the main presentation, and I invite Mr. Lars Broker, the President of Constitutional Court and High Administrative Court, Ryan Falz of the Federal Republic of Germany, a professor, doctor, who will cover the issues of decisions of the Federal Constitutional Court of Ukraine and Germany on the principles of rule of law. I would like to say that Mr. Lars is good friends of our state. As professor, I have to mention that we have fruitful cooperation between Lviv National University and Mr. Lars on the program of parallel studying of German law, where Mr. Lars was very active. Thank you very much, and I invite you to take the floor. The audience is yours.
Dear Mrs. Chair, dear judges, dear friends, it's a great honor and also a great pleasure for me to do some remarks today on the principle of the rule of law, and it's on the occasion of the Constitutional Day of Ukraine. And I'm very glad seeing so much well-known colleagues and friends, especially in this session 3, in this panel with Oksana and Oleksandr. It's very nice to meet you again. So because of the time limit, let me start immediately and begin such as justice must never be accommodated to politics, but politics must always be accommodated to justice. As early as 1793, the elementary form of the rule of law, in particular the supremacy of law, was asserted and emphasized in this way by Immanuel Kant. The rule of law means that all power is bound by law. In the 19th century, it was primarily the administrative law and thus the administrative jurisdiction which ensured the compliance with the principle of legality and administrations. Seen in this way, the administrative law operationalizes the rule of law. Administrative and constitutional jurisdiction together establish, stabilize, and ensure the rule of law, a means of judicial legal protection. According to the basic law and the legal practice of the Federal Constitutional Court, what does the term principle of the rule of law exactly mean? Where exactly in the basic law is it stipulated and how is it designed in detail? And so far, three findings are crucial in this respect. First, the basic law does not know one single principle of the rule of law, but the principle of the rule of law, according to the basic law, bundles a number of individual manifestations, which means dictates of the rule of law, which in their entirety are referred to as principle of the rule of law. As early as 1953, it was decided by the Federal Constitutional Court. Second, according to the basic law, the single dictates of the rule of law are not only formal, but also substantive in nature. It is not only a matter of formally binding the state power to comply with the law, but also of the substantive content of that law. And third, the individual manifestations of the principle of the rule of law can be in conflict not only with other structural principles of the basic law. It can also be necessary to balance them in a single case, which means to weigh them up with the scope of the principle of the rule of law. Finally, individual manifestations of the principle of the rule of law may come into conflict with the fundamental rights, especially in cases involving multipolar fundamental rights relationships. So, and to illustrate the latter, I would like to depict a short and highly relevant exemplary case on the ne bis in idem principle. But firstly, let me talk about the location of the principle of the rule of law in the basic law. The rule of law is explicitly mentioned only in Article 28, paragraph 1 of the basic law, whereas the constitutional order in the federal states must conform to the principles of a republican and democratic state governed by the rule of law within the meaning of this basic law. This is the so-called principle of homogeneity. In this way, however, the principle of the rule of law is only mentioned in the matter, but not elaborated upon. Therefore, in the context of its continuous legal practice, the Federal Constitutional Court sees the principle of the rule of law, at least since about 1973, in accordance with Article 20, paragraph 3 of the Basic Law, which reads as follows: the legislator shall be bound by the constitutional order, the executive and the judiciary by law and justice. Thus, Article 20 can be seen as a short form of the rule of law. As a further reference, Article 1, paragraph 3 of the Basic Law can be mentioned. It reads as follows: the following fundamental rights shall bind the legislator, the executive, and the judiciary as directly applicable law. In other words, it is valid either way, as stipulated by the Federal Constitutional Court already in 1953, that in each individual case, single manifestations of the principle of the rule of law under basic law, as well as further derived legal principles, such as principle of proportionality and protection of the legitimate expectations, have to be taken into account in every case. The question for solving a case is always as follows: which exact manifestation of the principle of the rule of law is specifically affected? That is the starting point for the constitutional review. Well, the formal meaning of the rule of law, as it is used in Article 20, paragraph 3 of the Basic Law, is the principle of the rule of law par excellence. It's done by the Federal Constitutional Court And it's based on the fact that this norm names and lays down the central manifestations of the former rule of law, which is the principle of the separation of powers, which is mentioned as a core of any constitution based on the rule of law, the legality of administration, supremacy of law, reservation of the law, supremacy of the constitution, and effective protection of rights, which is very important for the administrative jurisdiction and the administrative courts. But however, the principle of the rule of law goes clearly beyond the aforementioned, essentially strictly formal bindings and requirements. The principle of the rule of law is not devoid of values. It directly contains substantive requirements which in their entirety and intensity, sometimes more, sometimes less, can be regarded as a special feature of the German constitutional order, as it is the protection of the basic rights, the principle of proportionality, which sometimes leads to conflicts with the European Court of Justice, as you know, the legal certainty and protection of legitimate expectations, the consistency of the legal order, and at least the civil servants. Civil service, this means a significant proportion of the civil servants, especially those with sovereign functions, are part of a historical lineage in Germany that goes back to the Kingdom of Prussia and Bavaria. And the Federal Constitutional Court explicitly names the civil service as a supporting element of the rule of law. And most recently in its decisions in 2008, 2018, and 2020. But now let me come to an exemplary case that might be interesting for you. It's upon the ne bis in idem principle, because on May the 24th this year, the Federal Constitutional Court heard a constitutional complaint of a man who was accused of murder and rape more than 40 years ago, and he was acquitted. 30 years after the crime, thanks to technological advances, the trace evidence from the crime scene could be examined better, and the evidence found led investigators back to the man who has been acquitted. However, the criminal law did not allow new investigations. The exceptions in which a new proceeding is admissible after a final acquittal are very limited. For instance, in cases when the affected party confesses to the crime, which was not the case here. This situation deemed unbearable for most people in the political community. In such cases, substantive justice had to be enforced against the idea of the legal certainty. For this reason, 2 years ago, the German parliament, the Bundestag, passed a law providing for the possibility of reopening a case if evidence subsequently emerges that provides urgent grounds for convicting a previously acquitted defendant. At the same time, the legislator limited this possibility to criminal offenses which are not subject to the criminal statute of limitations, such as murder, genocide, and war crimes. Once the prosecution started against the investigations based on this new legal act, and the criminal courts confirmed it, the man filed a constitutional complaint. He could even achieve that the Federal Constitutional Court had doubts of the constitutionality of the new act and ordered the release of the man from the pre-trial detention, albeit subject to strict conditions. But the decision was made by a slim majority of 5 votes against 3 in the court. In his constitutional complaint, the man claims that the act is breaching the principle ne bis in idem, which is an integral part of the principle of the rule of law in accordance with Article 103, paragraph 3 of the Basic Law. Although this article explicitly reads, no person may be punished for the same act more than once under the general criminal laws, in the legal practice and literature, this prohibition is predominantly derived from the principle of double jeopardy. It does not seem mandatory to me, but still there are many indications, in particular as the course of the hearings has shown, that the Federal Constitutional Court will adhere to this broad interpretation of the scope of application of the prohibition of the double jeopardy. Nevertheless, the Federal Constitutional Court will have to elaborate in which extent the prohibition of the double jeopardy can be limited by the legislator. The point is that not only the substantive justice and the penalty claim of the state would be compromised if a renewed prosecution was not possible. It also and essentially affects the fundamental rights. Here, the rights of the relatives of the victim. Since the Federal Constitutional Court decided in 2014 and again in 2020 that no general entitlement to state prosecution exists, but a claim for an effective prosecution as a constitutional right can emerge inter alias along to two other constellations which are not applicable in this concrete case, due to the duty of the state to protect basic rights, to protect and promote the life, physical integrity, freedom, and sexual self-determination of an individual, and to protect him from unlawful interference by third parties. Following the argumentation of the Federal Constitutional Court in accordance with the principle of the rule of law, waiving an effective prosecution of such crimes could, and that's in the words of the Federal Constitutional Court, they lead to loss of confidence into the state monopoly to use power and the general climate of legal uncertainty and violence. The Federal Constitutional Court further states, this claim is in line with the state duty to undertake effective official investigations when an individual lost his life as a result of violence, and derived from the European Court of Human Rights decisions according to Article 2 and Article 1 of the European Charter of Human Rights. The court will announce its decision in several months. Observers expect that the decision will be made with a slim majority of the court. In my view, there is some evidence that the protection of the basic rights in this concrete, narrowly delimited case of exception allows to limit the principle ne bis in idem as implemented by the legislator. In such a case, a renewed prosecution would be possible, well, in my opinion. This may be also valid in the concrete case, despite the retrospection challenge, which has to be considered here. So as a keyword, protection of legitimate expectations, but provided the confidence of the accused into continuity of the existing legal status will be classified as not worthy of protection based on a judgmental evaluation. Thus, the legal act would comply with the Constitution. We will see in several months whether the Federal Constitutional Court has the same view. But to conclude my presentation, I would like to come back to the citation from Immanuel Kant, which I mentioned at the very beginning. Justice must never be accommodated to politics, but politics must always be accommodated to justice. The quote should not be misunderstood in the way that policy cannot be enshrined in a new law and adapted so. This is self-evident for a democratic state governed by the rule of law. However, in the democratic state governed by the rule of law, even the legislator is not absolutely free, but bound to the supremacy of the Constitution. Political actions are bound to law. In historical terms, and sometimes even today, lines of conflict have been seen between the principle of the rule of law and the principle of democracy. Mostly, they can be eliminated. The basic law sees both principles in a logical relationship of a mutual dependence. Democratic order means more than implementation of political views of a majority. The tyranny of the majority, as Tocqueville called it, could not be hindered without legal binding. The central prerequisite and thus the task of a democratic order is and stays to ensure equal freedom for all citizens. According to the Federal Constitutional Court, the principle of democracy means the right of citizens on democratic self-determination. This necessarily requires protection of minorities by means of law. In turn, this can be guaranteed only by normative stipulations. The Federal Constitutional Court clearly expresses this interaction and the required interplay between the principle of the rule of law and the principle of democracy in its decisions on the basis of the formula free state governed by the rule of law and free democratic basic order. So both terms go together. According to the Federal Constitutional Court, a sustainable democracy cannot be guaranteed without legal restraints. The own self-restraint, which is already inherent in the principle of democracy itself, understood in this way, allows to eliminate the apparent conflict between the principle of the rule of law and the principle of democracy. Or speaking with clear and expressive words of the Federal Constitutional Court in its 2016 decision in a proceeding concerning prohibition of a political party, there the court said, temporary rule as the essence of democracy requires that the majority constantly competes with the minority, and this minority has a chance to become the majority itself. The temporary majority must not close the open door that it has used to enter behind it. Thank you very much for your attention and giving me the opportunity to share some experiences. Thank you very much.
Пане Ларсе, дякуємо вам за таку чудову.
Thank you, Lars, for sharing your observations with us from your perspective, from your presentation. We can understand how the Federal Constitutional Court sees the rule of law and how it applies this understanding in its case law. Another very important issue that you've risen that is very important for Ukraine. This is the finding this fine balance between the rule of law, human rights, and certain restrictions. And this balance should be struck very carefully. And if we proceed from the concept of the democracy of values rather than the procedural democracy, it is essential. And the point of view of the position of the Constitutional Court that you've quoted is extremely important. Thank you very much, dear colleagues, for posing or say sporting the flag of Germany, the flag of the European Union, and the Ukrainian flag behind your back. Thank you very much for this manifestation of solidarity. We feel this solidarity and support today and hope that in the post-war recovery, you will be standing by us as well. Thank you very much. And now I would give the floor to the authors of our interventions. And first of all, it is my great pleasure to give the floor to Oleksandr Tanasa, long-standing friend of the Constitutional Court of Ukraine, special advisor of the Constitutional Court of Ukraine, president of the Constitutional Court of the Republic of Moldova in 2011-2017, former member of the European Commission for Democracy through Law. And he almost always participates in our events, very generously sharing his opinions and expertise. Regrettably, you are not with us physically, but you are with us online. And I invite you to speak about the role of the Constitutional Court in preserving democracy in the modern world. The floor is yours.
Thank you, Oksana. Dear colleagues, dear friends, ladies and gentlemen, I am very happy to see you after a long time for a long break because of the war. No, we cannot meet each other physically, and unfortunately, I cannot visit my lovely city, Kiev. It is a great honor and pleasure for me to have been invited to speak at this conference dedicated to the Constitutional Day of Ukraine. This invitation holds special significance for me, not just because I am a retired constitutional judge, but especially because of my deep personal connection with Ukraine and the Constitutional Court of Ukraine. As we celebrate Constitution Day, we truly commemorate the triumph of the rule of law over the arbitrariness. Although I was born in 1979, in terms of my constitutional philosophy, I am considered myself a child of 1989. It is the crucial year witnessed the fall of the Berlin Wall, symbolizing the establishment of the so-called religion of human rights between the ruins of the former communist world. The continuous struggle for human rights stands as the cornerstone of the evolution of human civilization. In this regard, let me refer to the text of the Article 16 from the French Declaration of the Rights of Man and of the Citizen, which asserts that a society in which the observance of the law is not assured, nor the separation of power defined, has no constitution at all. This definition of constitution emphasizes the critical importance of human rights and their close association with the principle of the separation of power, serving as a bedrock for the establishment of the constitutional system within a democratic state. Let me say that Article 16 of the French Declaration beautifully encapsulates the core principles that form the foundation of the widely recognized religion of human rights. Celebrating any anniversary provides an opportunity to not only to acknowledge achievements, but also to discuss existing problems and challenges that lies before us. In the past 3 decades, democratic nations have strived to promote freedom, justice, and equality. In the meantime, some countries have succeeded while others have set back, experiencing a clear regression to Stalinism. The military aggression of Russian Federation against Ukraine is the most eloquent example how much the religion of human rights and the principles of the international law has been shaken in the last decade. In this condition, preserving constitutional values and principles remain the greatest challenge of our times. One of the biggest challenges to note is the erosion of the civil liberties. Being here in the Central Asia, of course, I have a possibility to compare the thing between different countries, different democratical models. Traditionally, the first victim of the erosion of civil liberties become the freedom of speech. Social media and the internet provide platforms for the free expression of opinions, but still at the same time, they can also contribute to spread propaganda, misinformation, hatred, and violation of rights of others. The tension between freedom of expression and the need to protect against harmful content requires maintaining a very thin, very delicate balance within the framework of constitutional values. The epidemic of repressive laws, which has been spreading in the last years from Russia, it's now affecting countries that were traditionally being considered democratic. Governments started now to easily offer a distorted social contract to the society, where security is proposed in exchange for freedom. The history vividly teaches us that those who choose security at the expense of freedom finally risk losing both of them. In this context, an effective and functional system of constitutional control serves or could serve as a kind of insurance against such harmful choices. The next significant challenge facing constitutional values in our time is the rise of populist manifestations. These manifestations directly affect the constitutional values. The populist party, as proven by the experience of the past decade, tend to cling to the power they have gained throughout democratic means and never let it split from their hands. They manipulate the electoral legislation and suppress parliamentary and non-parliamentary opposition. They adjust the levels of power to minimize the likelihood of losing control over the power in event of change of the majority. These actions often involve technical and apparently unremarkable measures, the importance of which becomes evident when it is already too late to do anything about it. Quite often, constitutional control remains at the last effective means to counter populism and the abuse of political will, regardless of its source. Presidents, governments, parliaments, it doesn't matter. Of course, in this context, I cannot overlook another aspect of populist manifestation in this context. I mean the judicial populism. It's not less destructive than populism originated from the political sphere. To resist threats from political authorities, the court resort to a dangerous strategy to adapting their decision to prevailing trends and public sentiments. Another contemporary challenge to constitutional values is technological progress. With the advancement of the data collection, storage, and processing technologies, privacy and personal data protection questions are becoming increasingly acute. Technological capability for mass surveillance and control can lead to a significant limitation of civil liberties, and constitutional values such as the right to privacy risk become an illusion. In poor countries, a collateral effect of technological development is known as a digital inequality. People who lack access to modern technology or do not possess the necessary skills may find themselves excluded from the digital space and deprived of the opportunities it offers, thereby aggravating social inequality. This contradicts to the principle of equality and justice enshrined in the constitutional values. No doubt that the future belongs to technology. Therefore, it's crucial to constantly, for the constitutional courts, of course, to constantly adapt and update the legal constitutional framework to effectively regulate and balance the impact of technology on the society while preserving and protecting constitutional values. Dear colleagues, one of the primary goal of the constitutionalism, of course, is the legal limitation of power. Thus, controlling the constitutionality of law and condition of independent and absolutely impartiality. It's a fundamental element of democratic regime. The politicians, the political sphere should not perceive this mission of constitutional courts as an attempt to undermine the monopoly on power. Law is not absolutely truth just simply because it's the law. It is worth mentioning that slavery also been unjust, even if at specific historical period it was sanctioned by the law. The mission of the Constitutional Court, particularly in modern legal system, is to ensure that the laws are and actions of the government adhere to the principles and values enshrined in the Constitution. By engaging in constitutional control, societies can confront historical injustice, challenge discriminatory practices, and ensure that the law evolves to reflect involving social values and more progress. To conclude my presentation, I will refer to Hans Kelsen, who defined the constitutional courts as the guardian of the Constitution. Thus, the protection of the constitutional values encompasses democracy, the rule of law, and human rights, relies heavily on the moral courage of those entrusted with guarding the Constitution, notably the constitutional judges. Their unwavering commitment and moral fortitude are indispensable for preserving constitutional values, upholding human rights, maintaining the rule of law, and fostering justice within society, even in the face of adversity, including times of war. I am convinced that the Ukrainian constitutional judges have such moral courage. In closing, I would like to extend my heartfelt congratulations to the Constitutional Court of Ukraine on the 27th anniversary of the Constitution of Ukraine. The court's unwavering dedication to upholding the principles and values enshrined in the Constitution, even in a wartime, is commendable. Your tireless effort in safeguarding constitutional rights, preserving the rule of law, and ensuring justice for all Ukrainian citizens are crucial in the nurturing a strong and democratic society. May the Constitutional Court of Ukraine continue to serve as a pillar of justice and guardian of the Ukrainian Constitution, inspiring confidence and promoting the principle of democracy for years to come. A happy anniversary, dear colleagues, and the best wishes for continued successes in your noble endeavors. Thank you.
Дякую. Дякую, пане
Thank you, Mr. Tanasa. Thank you, Oleksandr, for your understanding and support of Ukraine, for the premise that you communicated to us. Security cannot be exchanged for freedom. Otherwise, you can lose both. Now that our people are fighting for this freedom, your support is paramount. Your premise that the mission of constitutional control is to make sure that the legislature and executive authorities should be consistent with the constitutional values is important, whereas constitution is a set of principles and values, and that demonstrates our common understanding of these values and our common European aspirations and European identity. Thank you yet again, and now I will give the floor to Mr. Oleksandr Petrosyan, Judge of the Constitutional Court of Ukraine, Doctor of Law, Professor, full member of the National Academy of Sciences of Ukraine, and the President of the Academy of Legal Sciences. He understands the doctrine and the theory of law, constitutional law included, and he will be speaking about the interpretation of constitutional norms in the implementation of the principle of the rule of law. The floor is yours.
Доброго дня, шановні колеги, дорогі
Good
друзі.
afternoon, dear colleagues, dear friends, our distinguished international partners. I'm very pleased to talk to you today. We have gained a lot of experience together in terms of developments of draft laws and also plans for development of amendments to the Constitution. And hopefully, going forward, we will still have this opportunity to talk, to share our opinions, to share experience, to make sure we achieve this joint European identity, to make sure that we win over our enemy, because it's not only about war for the territory or war for resources, it's about war of values. And today I liked the point expressed many times that our European choice was the cause for this military aggression. When it became clear that Ukraine is going by the path of Eurointegration, Ukraine goes back to its European home. However, as regards the presentation, I would like to start this presentation with the opinion formulated by Mr. Mykola Gnatovsky, our old friend and partner, that the best constitutional court today is the European Court of Human Rights. Especially at this moment, we have significant resources and capacities to take the way of Eurointegration, and in the sense of our constitutional jurisdiction, in the sense of triads of European values mentioned by distinguished Serhiy Petrovich. And in this sense, it seems to me we need to look at our ongoing activity without cases, without subject matters, to what extent we have the progress on this path to the European values, to the rule of law, first of all, or as we say, the supremacy of law. I'd like to dedicate more attention to interpretation of constitutional provisions and implementing the principle of rule of law. How this promotes the implementation of principle of rule of law, and what are the problems and how we can overcome them. We all are well aware, especially our judges of Constitutional Court. I will not be talking about the powers, the mandates of the court, but one of the important powers is performing official interpretation of the Constitution of Ukraine. It is treated not as the main power. The main one is the verification of legislation, the verification of laws and other acts in terms of their compliance to the Constitution, but also official interpretation of the Constitution. In this sense, we have a number of issues in the context of today's problem, ensuring the rule of law. And it notes that the Constitutional Court of Ukraine already raised these matters. We raised the matters of what is the normative interpretation in the activity of Constitutional Court and what is official interpretation of the activity of the Constitutional Court. First of all, I would like to emphasize that execution of any powers of Constitutional Court is linked to the problem of interpretation. Moreover, as we understand, beyond this activity, the activity of interpretation of the provisions of the law, the execution of any powers of the Constitutional Court is impossible. In this sense, the leading American philosopher Ronald Dworkin justified the interpretational concept of the law. He states, and this is well grounded, that the contents of the provision of the law is established exclusively as the result of interpretation of the provisions of the law in the context of specific case. or situation which should be solved using the law. I believe that this concept is very promising. It is not yet dominating and it's not widespread, but I see significance in this. The content of the provision of the law is established when we interpret this provision in the context of the specific case. And I'd like to remind us that the constitutional jurisdiction was initiated due to the need to resolve the matter of compliance of some provisions to the Constitution in the context of resolving specific problem. This well-known case, Medicine of 1803. If we go back to European tradition, and Gans Kelsen in the past justified this model of constitutional court as the protector of the Constitution, and he should be honored for that. It's not by chance that he is called the most leading theoretician of the law of all times and people, at least as of today. Hans Kelsen proposed three conditions for functioning of constitutional jurisdiction and constitutional court. First condition is said about logical cohesion of the provisions of law, starting with general provision, then constitutional, and then legislation, then acts of enforcement. And the content of law, he was searching for it in the hierarchy of the sources of law, only in the hierarchy of the sources of law. The second condition, according to him, was protection of rights of parliamentary minority from the position of understanding of democracy, which was mentioned today as well. And the third is the function of negative legal drafting. To execute any of these functions, it is based on the need to interpret the provisions of the law. However, what do we mean when we say we have separate powers to interpret constitutional provisions and official interpretation? What does it mean based on the analysis of the situation? The first thing I'd like to note is that according to the first law on Constitutional Court of Ukraine of 1992, when the Constitutional Court was not established, except for the chairperson, we did not have the separate power of interpreting the provisions of the Constitution and the law. That is, interpretation was part of executing other functions. However, in the 1996 law on the Constitutional Court, we have a separate interest in power, which is interpretation of the Constitution and laws of Ukraine. I would like to emphasize this. We had a situation when the parliament discusses in the committees, in the parliaments, and they adopt the laws. However, they cannot interpret the laws. Laws can be interpreted only by the Constitutional Court. Then the 2017 law on Constitutional Court narrows down this power to the official interpretation of the Constitution of Ukraine. This is interesting. In the transitional arrangements of this law, it was mentioned that the Constitutional Court closes all opens proceedings on the cases of official interpretation of the laws. Constitutional Court refused, even from interpretation of the laws that they had to interpret earlier. In this context, we have two problems. To what extent the abstract interpretation of Constitution promotes the reinforcement of the principle of the rule of law, and how justified it is to reinforce this principle, to provide this abstract interpretation of the official meaning that is generally compulsory. First, on the abstract nature of interpretation, I'd like to note that from the powers of all constitutional courts of Europe, and not only Europe, at least Europe, only 5 constitutional courts from EU countries have this power to interpret constitution. This is Albania, Andorra, Bulgaria, Moldova, and Slovakia. These are 5 European countries. The powers of Federal Constitutional Court on interpretation of the basic law is clearly linked to presence of disputes on the scope of rights and duties of the high federal body or other entity. And from this we derive another issue, how these powers are implemented by the constitutional courts of the European countries. For example, Constitutional Court of Albania emphasizes in its rulings that court, during performing constitutional control, should not act as legislator. There's a separate case when there is ambiguity of the provision or existence of clear link between specific constitutional provision and facts, contradictions on this matter, and position of the bodies which implement these constitutional provisions. The Constitutional Court of Moldova pays attention to the following. When interpreting Constitution, the cognition objectives should not be implemented. Interpretation is not done to get to know something. In the law of Ukraine, it says that we need to justify the grounds which caused this need for interpretation, but it is not mentioned what are the grounds. At the same time, in one of the rulings of the Constitutional Court, it is clearly specified that avoiding collisions in the legislation, avoiding the gaps in the legislation according to the legal position of this Constitutional Court, does not belong to the competence of the Constitutional Court of Ukraine. A separate problem, another problem, is legal force of these interpretations of the Constitutional Court in the context of their relationships with the current laws, because the laws are adopted on the basis of the Constitution and to fulfill the Constitution as a result of some interpretation of the constitutional provisions. And we have a new type of acts of Constitutional Court Interpretation Act, which is different in its form and structure from other decisions of Constitutional Court. First of all, in negative legal drafting. This problem was, there was an attempt to solve this problem by a Supreme Federal Court of Brazil, which acts as constitutional jurisdiction. How do they solve this matter? The result of abstract interpretation of the constitutional norms are treated like the court precedent, and then they become compulsory, mandatory as the court precedents. They're also mandatory beyond these individual cases. And it's another matter is official nature of abstract interpretation. First of all, I'd like to draw your attention that none of the laws on constitutional court of the European countries has said that this interpretation is official. The term official is not applied in Europe. Why? Because it's clear if the state body does interpretation, this interpretation is official. But why do we need to emphasize that this is official interpretation in our case? I believe that to a large extent it boils down, it's not only a reference to authority, as the interpretation performed by the most competent experts in the area of constitutional law. But when we emphasize that this is official interpretation, we would like to emphasize that we want to make sure it is generally obligatory and it is compulsory based on some enforcement measures if it is not fulfilled. As a matter of fact, to summarize, it is about giving some parameters for the activity of the parliament. Based on abstract interpretation of the constitution, we set some parameters for the legal drafting activity of the parliament. This is close to what they call in France the third chamber of the parliament, when the Constitutional Council of France is sort of third chamber of the parliament. But we understand that from the perspective of this concept of division of powers, delimitation of competences, these things in a general sense are not acceptable, or there is limited room for this. What are my conclusions on the basis of this analysis? The conclusion is similar to what was said by other speakers. In particular, our German partners mentioned this and other international partners, and also we mentioned this, that the Constitutional Court, I'm deeply convinced that Constitutional Court should work, its main objective should be, Serhiy emphasized this, it should be protection of human rights. why the Constitutional Court was created. It is the protection of constitutional rights, constitutional human rights, and this would allow us, based on the recent numbers, maybe they're not in line with reality, maybe our German partners can correct me, but there is a number that 95% of cases reviewed by the Federal Constitutional Court of Germany are dedicated to what we call the protection of constitutional rights and constitutional complaints. And as it seems to me, there is a great potential for development of our constitutional jurisdiction and for taking this position. And also, Mr. Mykola Gantowski should not tell us that Constitutional Court of Ukraine implements itself in the activities of the European Court of Justice. Thank you very much for your attention. Thank you for your presentation, dear Oleksandr. Thank you for your well-grounded study, as usual, of the official interpretation of understanding of this interpretation. The functions of Constitutional Court as the protects, as defender of the Constitution, as negative legislator, and emphasis that the content of the provision of the law is established in the context of the case that should be solved, and the emphasis on the role of constitutional complaint in this area. We can make the conclusion that this is effective protection of the human rights. And once again, our next speaker, our friend for many years, Ms. Oksana Shcherbanyuk, the head of the Department of Constitutional Law of the Legal Faculty of Chernivtsi National University, named after Yuri Fedukovich, professor of Vilnius University, doctor of legal sciences, professor, member of Scientific Consultative Council of the Constitutional Court of Ukraine, with presentation on rule of law as meta principle of the constitutional system of EU. Please, the audience is yours. Dear colleagues, dear Serhiy Petrovich, thank you very much for invitation, dear judges, dear participants of the conference. Sincere greetings on this occasion, on the anniversary of the Constitution Day, and let me make a quick presentation on the outlined topics. No doubt the rule of law is one of the number of principles which is considered to be the groundwork of the political order of the EU. It is common for the EU member states, and we can say that this is general principle, but we have the question, what is the significance, what is the scope, what is the normative impacts of the rule of law in the constitutional system of the EU? In the past, in the significant decision, significant ruling, Vasyl versus Parliament, the European Court of Justice, also European community as the community based on a rule of law. Although neither the states nor the institutions of EU cannot avoid review of compliance of their acts to the constitutional charter. At that time, it was in the Treaty of 1957 on the foundation of EU, but then the constitutional document of the states based on rule of law was acknowledged, and although constitutional narrative of court was criticized at that time from all sides, the reference to traditional concept of rule of law mostly was greeted, was welcomed at that time, and indeed, at that period of time, maybe we can say it in the 1960s, end of Cold War, international organizations, national governments, depending on the regimes, especially try to express their support to the rule of law. Indeed, the rule of law is identified with the idea of right of people. Often, Al Marshall, in the case of medicine versus member, medicine versus medicine case is often referenced, but much earlier in the 30th article of the Constitution of Massachusetts, state of Massachusetts, it was mentioned that there is a rule of law and not rule of the people. The Court of EU emphasizes the importance of character of rule of law as decisive element of constitutional character of EU. I have to note that before this time, in the European science of constitutional law, there is still ongoing discussions on the semantics, semantic complexity of definition, the reinforcement of rule of law in constitutional legislation, supranational state order. This creates issues, and for this, we have to apply comparative analysis which would allow to critically evaluate how rule of law, constitutional principle of EU is different from how this notion is understood and applied mostly by the national constitutional traditions in Europe.
Analyzing the literature of today, we may find a whole range of different definitions, but most authors agree that the rule of law is a fluid notion, and it is very akin to the notion of the good. And we are guided by the constitutional principles of the EU, and the EU is based on the international agreement and treaties. So we now look at the agreement on the founding of the EU to look for principles, constitutional principles including in it. According to the national traditions, the principle of the rule of law has become the dominant legal paradigm, so to say, umbrella principle with different elements, but the rule of law in the EU is broader in application than at the national level. So perhaps it would be logical to see the uniformity and multifaceted nature of the application at the national level on the one hand and at the international level on the other. When it comes to the essential differences between the two in how institutionally the rule of law is implemented, we should understand that it is the basic principle underlying all European constitutional systems or frameworks. Not only is it a joint political choice, but it is a common legal principle, the constitutional value. Yet it does not mean that it is reflected in each and every constitution, particularly of the so-called old Europe, with the only exception of Italy and Spain and Portugal that have that reflected in their constitution. However, constitutional courts and constitutional law experts refer to this principle on a regular basis to assess the constitutional order or address a certain constitutional problem. And when it comes to the new members of the EU, they incorporate this principle into the text of their constitution, which means that the principle has been broadly acknowledged by legal experts or professionals. And the rule of law, the content and the elements of the rule of law are not clearly defined by either the constitutions or the constitutional courts. The British rule of law, the État de droit, German legal stat, and others are established by the so-called meta principles that ensure the fairness and legality of the court system, and they show whether there are some formal limitations given the rights of the individual and interference into those by the public authorities. And a majority, if not all, of the constitutions or courts in Europe consider formal and contentional or content elements of the rule of law as mutually dependent rather than mutually exclusive. In democratic European states, such elements as proportionality, protection of new rights, irreversibility, etc., are based on the values of human dignity, legal autonomy, etc. And the large range of legal standards allows to implement the rule of law in various aspects, which makes the entire political and legal system elegant and comprehensive. And Oftentimes, the understanding of the rule of law is used as either political or legal baseline to assess deficiencies in legal mechanisms or in legislation. For example, the principle of the law-guided state after 1949, it cannot be understood without referring to the situation at that period. Even if the basic concept of the rule of law can be derived from various legal traditions, nonetheless, implementation of this principle should go in different ways. As a result, the exact list of principles and values can be different in different countries, even though the European legal systems share the use of formal and material standards and values. So the institutionalization of the rule of law leads us to the implementation of different constitutional mechanisms. In Germany and in France, for example, the respect of the rule of law predetermined the establishment of constitutional courts to exercise constitutional oversight. But in Constitutional Council of France, the status is higher than in Germany. And the last element is that the principle of the rule of law, even though it is interpreted as the basis for judicial procedures, is such that cannot be the subject of a judicial consideration. It does not mean that it has no descriptive function. On the contrary, it is mandatory, and the courts rely on it as a cross-cutting principle while administering justice. What are the common and features and differences between the national law and the EU acquis? In this context, we should assess it in the light of the case law of the ECTHR. The rule of law in the EU has certain specific features. It has broader applications than the one at the national level. Likewise, it is used as a benchmark, but it is correctly treated or viewed in organic relation with other principles defined in Article 6 of the Treaty of the European Union. And we refer to this article several times during the day today. This principle in this context is a key benchmark for interpretation, and it is the second important normative function that we discuss in the context of the EU integration. Of course, we all know the Soft Law Act reports on the rule of law, and we take it into account while teaching our students. But I would like to draw attention that some time ago, in 2014, the European Commission adopted the frameworks of the rule of law. It was the first attempt by the EU, by the European Commission, to give the exhaustive definition of the rule of law within the internal context. And the decision of the European Commission reflected the opinion whereby there is a consensus about the main legal meaning of the rule of law, and that this concept provides for the six major principles: legislation, legal certainty, effective trial, and the equality before the law, etc. So the European Commission recognized that the exact content of principles and standards of this rule of law can vary at the national level, depending on the constitutional order of every member state. But at the same time, it underscored that the six elements are derived from the constitutional tradition that is common for most of the constitutional orders. And the main provision of the rule of law should be seen from the perspective of the EU law. Rule of law should be understood as the constitutional principle with a formal and material component, and it is related inherently with democracy and respect of human rights. And now speaking about Regulation 2020, within the constitutional frameworks of the EU, the rule of law is used as a yardstick to see whether the internal policy is in line with the external policy, and sometimes there are original approaches to it. However, we know that this aspect is not absolute and unprecedented at the international level. The Council of Europe has formal mechanisms according to which the member can be suspended if the principles of the rule of law are seriously breached. And the mechanism of the EU seem to be more complex and ambitious. And Article 7 of the Treaty of the European Union allows to apply measures to any member state in view of the permanent, regular, and serious violation of the principles of rule of law. So preliminary sanctions can be taken in this regard. And the culmination of the addressing of this issue was the consensus definition in Regulation 2020, which, as we know, was not supported by two countries, Poland and Hungary, but the consensual nature of the rule of law reflects how we can see the broad consensus in the European legal space when it comes to the major function of the rule of law and its legal definition as the key principle and the source of the standards of the judicial revision or court revision, and then how the rule of law correlates with such values as human rights and democracy. I would also refer you to the annual report of the Commission on the Rule of Law, first published in 2020, and it pertained to Article 2 of the Treaty of the European Union and the observance of all of the laws in the acquis. Then the Venice Commission and other political institutions of the EU define the rule of law, its major components to be found in the national constitutional orders. Today, there is the understanding of the rule of law as a meta principle ensuring the background for the foundation for the operation of the constitutional system. So, and there would be certain formal and material limitations to the interference into the freedoms of and rights of an individual. And here we speak about approaches by the Council of Europe and the EU, and that is the substantive concept of the rule of law. I would not focus on this concept now. Alan described it once, and the experience of the Council of Europe shows that the notion of the rule of law migrated from the supranational to the national level, and we can see the reverse impact. National legal changes to the legal systems also affected the supranational one. And the European understanding of the rule of law is not static. It's not unidimensional. We can say that the development of the EU acquis and the case law of the ECTHR spurred the revision of the notion of the rule of law. So the development of law and legal theory shaped the national understanding of this notion and judicial interpretation and application of different aspects and components of the rule of law. The development of the national legislation under the impact of the EU membership shed light on certain innovations that can be actually borrowed or even sent to other countries. And we are speaking here about intermingling constitutionalism. So we speak about horizontal and vertical diffusion of norms, which entail the rise of four major common characteristics between the European and national understanding of the rule of law. And a couple of more moments I understand the time constraints. The principle of the rule of law was the subject matter of the broad constitutional dialogue in international organizations, within the civil society, and in the academic community. This understanding is constantly being improved thanks to this dialogue. As matters stand, we should treat the rule of law as a meta principle that addresses the most fundamental issues of belonging and identity of meta policy. It is a meta principle that dictates or rather reveals other principles through itself. And to end, I would like to mention the position of the Nance, who is the chair of the EU Court of Justice, saying that the court should not be limited by the narrow understanding of the rule of law. We speak about the definition of the law to avoid the formalistic understanding of the rule of law, then the core of European integration and the system of checks and balances. This existential jurisprudence of the EU Court of Justice is based on the legal tradition, since the court aspires to protect the uniformity, the wholeness rather, and the integrity of the legal system in the EU. And complex cases allow courts to prove the principle of the rule of law. Now, Ukraine is in a very difficult situation. The conditions of the aggression and war, but no matter what crisis is, it does not undermine the European building more than the destruction of the rule of law could entail. So the rule of law is not just a slogan. We can see various functions and the positive impact on the protection of constitutional order in many member states. Thank you, Oksana. We can see that you are very passionate about this topic. Right. And we are in the united field of legal synergy. Oleksandr VODIANNIKOV spoke about the European integration, and you contributed wonderfully to this common understanding. Thank you. It is 4:30 Kiev time, and we can make the closing remarks now. Esteemed colleagues, my dear colleagues in the Constitutional Court, we are now discussing the topics of constitutionality, constitutionalism, and constitutional order. Now, I would like to appeal to all participants of this conference, first of all, to our international colleagues.
Мене, так мовити, статусно зобов'язує.
My status obliges me to make a short summary of what I have heard. I have to be concise because I'm convinced that my colleagues would like to add something because we can hear it differently and we can make our own conclusions. Dear colleagues, hopefully you will not criticize me that I formulated this topic in this way. They say no. So when there was a task to formulate the topic for the annual conference, this time I thought that Ukraine gains the new legal status. And why not? Why not talking about this? And from the perspective of retrospective and from the perspective of future perspective, from both points of view. I would like to remind you our great poets of the 19th century, first half, Taras Shevchenko writes, when we will get the new and right law from the Washington, and then he answers, oh, we will have time, the time will come for this. Taras Shevchenko was not studying Yale or Harvard or Heidelberg or Leiden or Vienna. However, he started in the church parish school. He started how to carry water, but he is named as the prophet of Ukrainian nation. In the first half of 19th century, he prophesied that we're waiting for Washington, and this Washington was born on 28th of June. This Washington gave the new and righteous law to Ukrainian people. It is the new because Taras lived during the times of serfdom. It was times of slavery for Russian Tsarate, and it is righteous because it's just. And remembering Oleksandr Tanasov, who said that Constitution Day is the festival of democracy, I would rephrase it, and I would say Ukrainian Constitution Day is the festival of Triad of European values. Ukrainian Constitution, because Ukrainian Constitution contains everything. All these values are present, they are embedded, they are fully implemented, they're enshrined as in stone. And when I have heard the opinion on the new Constitution, personally, my personal opinion was always we need to appreciate what we have. Our Constitution is our national value. It has our national identity and it has our European identity because it has values, real democracy, human rights, and rule of law. Our task is to help to implement this, and our today's topic on, let me remember, Mr. Granat, he quoted, he says that the Constitution always has to pass the time and to be tested by practice. Actually, he repeated the words mentioned by the Venice Commission when they made the opinion on our Constitution. In 1997, they said that it contains these drawbacks, especially in democracy and in the separation of powers, the triangle of power, president, cabinet of ministers, but it has to be tested by practice. And we see in practice where going forward, when we move to real democracy, when it corrects those deficiencies which are present in this triangle. There is dualism of executive power in this triangle, and we need to improve this, we need to have better quality of this constitutional legal order. Once again, going back to Tanas, who mentioned Article 16 of the French Declaration, which sounds like the society in which there's no division of powers and human rights are not protected, has no constitution. This is great. And today, when we discussed that we have division of powers in Ukraine, which appeared after approval in 1996, it was mentioned, but this is not true, because in 1995, we signed the constitutional agreement, which mentions that at that point, the division of powers was implemented into legislation power, executive power, and judiciary. And because of that, Ukraine gained the membership in the Council of Europe, because without division of powers, you cannot join the COE. And I would like to emphasize, when we talked about to what extent about the ratio of this triad of values, so human rights and democracy especially, we emphasized the current situation, the state of war. It's not just martial law, it is legal martial law when the power has the government has all powers, and they used it to suspend human rights according to European Convention, but we need to look at practice, and in principle, no European country after approval of European Convention for Human Rights, after the foundation of European Court for Human Rights, after developments of all European instruments of protection of human rights, they did not have this situation in practice. They didn't have real martial law with daily hostilities and with daily victims among civilians and also military personnel. And this influences the efficiency or effectiveness of these values: human rights, democracy, and rule of law. And in principle, Ukraine tests it on itself. We cannot say that when there was an issue on the pause, is democracy in Ukraine on pause? The democratic institutions still function. The state seemingly continues to function according to the constitution and determined competences. Of course, there are things which have the impact, no doubt about that, but it is not drastic impact on democracy. And when we talk about this relationship, only points I like the point expressed by, let me have a look, it was mentioned by Lars Broker. I really loved this phrase. He used to finish his presentation. It was on majority rule. The ruling majority should not close the doors through which it entered. This is a very good methodological point and also instruction. Human rights. Let me tell you the following. I took this topic and I started with this topic for a reason. Mr. Mykola Gnatovsky is here as the Ukrainian judge. You know what we have to do in Constitutional Court, how we need to overcome some problems. Due to the essence of the formulas in European Convention, due to essence of practice of the European Court, jurisprudence of European Court, and we, as Constitutional Court, encounter this when we review the individual complaints. When we discussed individual complaints, one of the speakers mentioned that, well, it was Mr. Mykola Gnatovsky or not, he mentioned that it is not complete in our case. Individual complaint is not complete. It's only 5.5 years old, and we selected incomplete constitutional complaints, which is characteristic for the German constitutional practice. We selected the normative complaints and only for the law. We do not treat regulations, only the laws. And this is the specificity of Ukrainian constitutional complaints, but let us look at the articles, 21st and 22nd of our Constitution. Article 21 says that it speaks in the language of Universal Declaration of Human Rights. All people are free and equal in their dignity and rights. Second, rights and freedoms of humans are intangible. Human rights, the rights of the individual, these are natural rights. And then we have the next article, which Article 22 has 3 parts, and we read Part 1. Rights and freedoms of human being and citizen are reinforced by this constitution. What is it? What is the relationship with the first article? There's a problem. Second part, constitutional rights and freedoms of whom are guaranteed. Third, when adopting new laws, we cannot change or narrow down the existing rights and freedoms of whom, once again, it's not specified. In the text of the Constitution, we have 4 terms and notions. In Article 22, 52, 92, 102, 116, and 157, we have term and notion, rights and freedoms of human being and citizen. In Article 22, we have constitutional rights and freedoms. In Article 64 and 101, constitutional rights and freedoms of human being and citizen. And Article 104, 119, 138, rights and freedoms of the citizens. And for us, it is not just the labyrinth. For us, it's not just the ski and slalom. I would say that this is slalom using canoe through the mountain river with many unexpected things. And we need to navigate using a constitutional complaint. We try to do so, and going forward, this will be one of the objectives of the next constitutional developer. When we go to the EU standards for European integration, these problems have to be solved, and ultimately, I don't want to take too much of your time. Our last speaker, Oleksandr, mentioned the rule of law as matter principle, and she referred to the acts of the European Union, the documents developed by the Venice Commission, the measurement of rule of law. It has nice graphs taken from the EU document. There is 3 circles overlaying one over another through democracy, human rights, and rule of law. And the circles are overlaid in a way that they have common core. There is no conflict between them. There is common core in some elements where all triads are the same, and they're not in conflict. Vice versa, they complement each other, they establish harmony, and it is the final category which has to be implemented as a result of political activity, legal activity, constitution changes, and activity of constitutional courts. I can make these brief conclusions for myself, and my colleagues can add more points and express their impressions. Thank you very much to all of you. Thank you for your participation, for being with us on this day, and for having this exchange of opinions, which is very precious in scientific and practical sense, and for our future activity. Thank you very much. Colleagues, you have 15 minutes to summarize, to discuss your impressions. Thank you for great moderation. Everyone is tired at this point. We can only thank you for selecting the topic, for summarizing And once again, let us thank our international participants for helping us. Thank you very much indeed, and see you next time. The next professional meetings to share experience, exchange opinions. Thank you, and see you next time in Kyiv. We'd like you to visit us in Kyiv as soon as possible, and when it happens, you understand when it will happen.
Дуже дякую. До побачення. На все добре.
До побачення, до побачення.
Thank you very much. See you.